Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. Our first case of the day is Sanchez Torres versus State of Florida. You may proceed.
May it please the court. This court should reverse Mr. Sanchez Torres' sentence and conviction because his plea was not entered voluntarily in the constitutional sense. The elements of the offense and using the totality of the circumstances, Mr. Torres did not enter an intelligent plea to premeditated first-degree murder. The record is clear, and the state concedes that the elements of premeditated first-degree murder, specifically the critical element of intent, was never read by the trial court or never affirmed in the entire record by trial counsel. And if you look at Mr. Torres' plea colloquy, he is specifically asked the question, why, give me in your own words, why you are pleading guilty to this crime. And I think you have to look at that issue because it's very, very critical. And he says, I'm pleading guilty because I didn't report the crime or something like that.
But then he also indicates during his plea colloquy that he was there, he was part of the robbery that was taking place, and so doesn't that indicate that he is in fact guilty of at least felony murder?
Perhaps. I agree that Mr.
Well,
Torres...
if a person is a part of a felony and someone is killed during the course of that felony, those that of course are listed in the statute that would qualify for first-degree murder, then you would be guilty of first-degree murder if you are a part of that felony, correct?
Correct, if there wasn't an independent act or some furtherance of that felony. If he acted in reckless disregard, the classic case is going into a convenience store and somebody says, I'm going to be the getaway driver and I'm going to be the robber and this guy gets shot. If there's not an independent act, I think you have to look at, again, the totality of the circumstances, which this court does in a sufficiency of evidence analysis of pleas. You have a guy who's given several statements in this case. And you have a guy that has said, this is an accident. This was not supposed to go down like that. In one statement, he says, I didn't even know my co-defendant had a gun. And what's also important in this case is that the state uses Mr. Sanchez Torres' statement in his co-defendant's case and takes...
Well, they don't really do that. In the co-defendant's case, and I wanted to be clear about what happened in the co-defendant's case, they put him on the stand and they did not ask him who was the shooter. It was the co-defendant's attorney that cross-examined him with the statement. So it is not, I don't see you raising an issue of a due process violation based on inconsistent statements. So let's try to stick to your first point, which is that the plea was involuntary. And on that, I want to ask, he did not ever move to withdraw this plea before, at any time in the trial court below, correct? So we don't have because you rely heavily on Henderson, which was habeas, we don't have a record really of what the attorney told this client or anything to tell us that this client did not have any idea what he was pleading to.
No, you don't.
And the judge actually gave him, for the weekend after he told him and accepted the plea, to think about it, to withdraw the plea. Is that also correct?
Yes, may I respond to that specific point? If you look at the plea colloquy, and that's an issue I knew this court was going to bring up. In the plea colloquy, the judge says, do you understand, Mr. Hector Sanchez Torres, that I can give you the death penalty if I find you are the shooter?
Well,
What's
again, I
important,
know we all have the plea colloquy.
Okay.
So you can take a particular sentence and answer, and if you take it out of context, but there is, to me, no question that this judge says on numerous occasions that that he is subject to the death penalty, and not just because he's the shooter. So we can disagree about that, but
Justice Pariente, if I may, the judge, what he does not say is, I can give you the death penalty if I find you are not the shooter. And that's very important in this case. He does not clarify that
well, let's go
position.
back to the first issue, which you said were the elements of the offense. You agree that there is no case that says that a trial judge must go over each element of the offense's charge in order for a plea to be knowing and voluntary. Do you
I
agree
agree
with that?
if there is record affirmation that the trial counsel did that. I think Henderson and I think Bradshaw v. Stump and also Gaddy of the 11th Circuit with Justice Joe Flatt writing the opinion, they make the determination, yeah, the trial court does not have to do a thorough reading of the elements if it is affirmed that trial counsel did some
Well,
kind of
that's
affirmation.
because, again, in Henderson, it was post-conviction. So they had, and you may have a good point for post-conviction to litigate. They were able then to have the attorney testify about what his conversations were with the client. But Henderson wasn't a direct appeal case, was it?
No.
Okay,
But-
well, don't you, so when you, we don't know because he didn't move to withdraw his plea, and because this isn't post-conviction, we don't know everything that his attorney told him in order to explain that he was pleading to first-degree murder, which would be either premeditated or felony murder.
You have enough here under the totality of circumstances to show that this plea was confusing. This entire plea was complex. The judge explains, do you understand that you're pleading guilty of premeditated murder, not based on the general premeditated murder theory, but under principle? And then he says, under principle because you're guilty of the robbery. He doesn't say under principle because you're guilty of the murder. This is the totality of the circumstances, which of course this court has a mandatory obligation to do. You don't need to file a motion to withdraw a plea on this case. This plea is confusing, it's complex, none of the elements are explained, principle theory is not complained.
But is the judge's statement about the robbery and his complicity in that, is that a correct statement that he could be convicted of first-degree murder based on his participation in the robbery? Is that correct?
Under felony murder, yes, Justice Quincy.
So, what you're really saying is that he cannot be convicted of premeditated first-degree murder, right?
Absolutely.
Okay, so it seems to me it goes back to the whole notion of whether or not the trial judge, not the trial judge, the trial attorney, actually talked to him about the elements of the crime. And that's something we don't know. We don't know. The attorney starts out this colloquy, right, saying the defendant wanted to plead guilty. But we don't know what the attorney said to him, whether he at first tried to talk him out of it, or whether he agreed and told him these are the reasons why this would be a good plea. I mean, we don't have that kind of information.
I think you do. I think you have enough to make that determination. In the plea
We
colloquy,
have enough in this record
Yes.
to determine what the trial attorney told this defendant.
yes, the plea was entered on the same day that the waiver was signed. The waiver, if you look at it, it's in volume 5 of 902 of the record, does not list the elements of the offense.
Well, let
When
me
the
ask you
indictment-
this. Is the record clear that that is the only time that the defense attorney talked to the defendant about the possibility of entering a plea?
I agree that we don't know that factor, but what we do know is we know that the elements were never read in the indictment. When the indictment was handed down in open court, and I cited in the reply brief, the attorney waived the reading of the elements. When you get to the plea colloquy, it is the absolute responsibility to make a finding that the defendant understands what these elements are, specific intent.
If the judge during the colloquy had said to your client, you can be found guilty of first-degree murder, and I can sentence you to death, if either the state proves premeditation on your part, or intent on your part to kill, or through felony murder, because of a robbery was being committed during the course of a robbery. If a judge has said that, then you wouldn't be here on this issue today.
Correct.
Now, take a step forward. Let's say there's a post-conviction hearing a while from now in this case, and there's an evidentiary hearing, and the trial lawyer in the case testifies. And during that testimony, trial counsel says, when I met with my client, I indicated to him in no uncertain terms that he could be found guilty of first-degree murder either through premeditation or as felony murder. And he understood. Now, would that suffice to have placed your client on notice as to what the issues are?
Well, I guess you'd have to go first through the credibility of the attorney that made that statement.
Well, okay, let's assume the lawyer says that, though, and you do nothing to prove that the lawyer is not credible.
Well, again, that's in post-conviction, and I don't have an answer for that. But the clear answer in this case is if that statement is made by the attorney, then why the heck do you have a defendant saying, I'm guilty of murder because I didn't report the crime? I think and this, again, under the totality of circumstances, if you're looking at this case, there, again, no indictment is read, no affirmation that this defendant knew or had an understanding of the elements. It was never asked to him in the plea. And
But you know, you're taking one statement without the other statements that he has made concerning his participation in this robbery and everything else. And so I can understand if that had been the only statement that the defendant had made, I would probably understand better your position here, but it's not. You keep talking about the totality of the circumstances. Well, the totality of the circumstances are that he made more than that statement.
Let me help you understand, Judge. The judge in this court, in this case, the trial court said, you are pleading guilty to premeditated first-degree murder. There is no discussion of felony murder. So if this court wants to say, start from the end and say, well, he's pleading guilty to felony murder when he was only told he was pleading to premeditated murder, we have a problem. That's exactly what happened in this case. He never, like Justice Labarga said, the judge never said, do you understand you're pleading guilty to premeditated first-degree murder and felony murder? I think this court can agree, and I think the state's going to concede this fact. Torres never talks about specific intent. There is no admission whatsoever in this record of specific intent of premeditated murder. And if you read the factual basis from the state in this case immediately after, they don't even give premeditated intent. They talk about who is the shooter. They never talk about whether Torres had specific...
Did you say that there was no reference to first-degree premeditated murder?
No, I didn't say that. I said there was a reference to it, but they never talked about the factual basis of how to get to premeditated murder, the facts of the actual case, Justice Kennedy. The state does say he is pleading to premeditated murder and felony murder. Unfortunately, what happens after that statement made by the prosecutor is the judge never affirms, do you understand that?
Well, he does, though. He does. The judge says, Mr. Sanchez, your attorney has just entered a plea of guilty on your behalf to first-degree premeditated murder.
That's what I'm saying, but he never said felony murder. What I understand this court to say is that Mr. Torres entered a knowingly plea to felony murder. I understand the court's trying to get me to concede they entered a plea to felony murder. However, when the court goes through the plea colloquy, he never discusses felony murder with Torres. So what I'm saying is if you're trying to get from the felony murder...
He certainly, Mr. Torres himself talks about facts that would directly support the felony murder. He says, I participated in the act. He helped plan the robbery.
I agree.
Okay? We've got that for felony murder, what came out of his own mouth. And then what we've got from the judge is the specific reference to first-degree premeditated murder.
But that's a difference, Your Honor.
I understand.
Yeah.
Both bases are covered, though, it seems to me.
Both bases are covered. Felony murder doesn't have specific intent. And
isn't that why, and again, this colloquy is not a model of, that we would put in the books as this is how you should have a colloquy, but you keep on saying totality of the circumstance. When we don't even require a jury to come back with we don't require felony murder or premeditated. You can find somebody guilty of first-degree murder, right, based on felony or premeditated. What is clear is that although the judge referred to premeditated murder, what I hear, what Justice Kennedy said, and I think is correct, is that this defendant knew that because he was a willing participant in a robbery, that he was guilty of first-degree murder, not premeditated, that he was guilty of first-degree murder. Would you agree that that's what this defendant knew, that he was guilty because he participated in the robbery?
I think there's enough on the plea colloquy to say that. Of
Okay,
course,
so
there's-
then
yeah.
why is it not because first-degree murder is either felony murder or premeditated, unlike Henderson, where the intent was important for second degree, since it's not important for felony murder, why would it be important to explain you had to intend to kill the victim, which is what I'm hearing. Is that what you're saying? That they needed to say you can't plead guilty unless you intended to kill this victim?
Not that he can't plead guilty, but he needs to understand what the elements are before
Well,
he
but no,
pleads
he
guilty.
understands that he can be held guilty, responsible, if he participated in a robbery and somebody ended up being killed. That's the essence of felony murder.
He's pleading to an element that was never given to him.
We don't require there be a finding of which brand of first-degree murder is a jury's finding. Why would we require it in a plea colloquy? As a matter of law. In other words, as a matter of that, therefore, this plea cannot be knowing and voluntary on its face. That's what, I'm not disputing that maybe this defendant was confused, could be, but where is that in this record?
Yes, Judge. The plain meaning, I would concede we wouldn't be here if there were a couple words said. And that's the problem in this case. If the judge would have said, Mr. Torres, do you understand you're pleading guilty of premeditated first-degree murder? It requires intent. Because it's clear in the record that Torres is not giving his intent to premeditated first-degree murder. And I also concede we probably would have a far lesser argument if the judge had explained you're pleading guilty to premeditated and felony murder from the beginning. That was, and Justice Kennedy, I know that's your sticking point, but that never happened. We're trying to take the cart before the horse and saying, well, because the state attorney brought up felony murder, that means that Mr. Torres obviously understood what was going on in this case. And again, there was...
But it's not just the attorney brought it up, that he said out of his mouth, he understood that because he participated in the robbery, he was responsible
for the felony murder, correct. And maybe we're talking about apples and oranges, but I think it's a very significant point. You're allowing somebody in a death penalty case to plead guilty and enter an admission to premeditated murder when the element has never been explained, and it's clear in the record he doesn't understand that that is an element.
Sentencing order.
Yes.
The judge says, in addition, prosecution provided a brief recital, actual report of their that defendant was the person who shot Eric Joel Colton during the commission of the robbery. So, as in all plea colloquies, usually the state provides the court on the record their recital of the facts that they believe they will be able to prove. And the defendant thereafter usually pleads guilty to those facts. Now, in these factual bases provided by the prosecutor, it seems to me that he basically said on the record with your client present that they will be able to prove beyond a reasonable doubt that your client was the one who shot Colon. I'm sorry, I said Colton. It's Eric Joel Colon. So thereafter, the colloquy begins, and your client pleads guilty to premeditated murder.
Well, again,
It's because the magic words were not used? I mean, what is it that you're looking for?
Judge, again, that could not be premeditated murder. There's a way that the defendant alleges a defense in here in saying I am not guilty of premeditated murder. Throughout the entire trial, pre-trial and after, he says that this was an accident. In another statement, he says my co-defendant had a gun. I didn't even know he had a gun. Okay, we're dealing with a case, and I think.
That's my. I used to do 10 or 15 of these a day.
Yeah.
Right? And it seems to me like no matter how extensive you make these plea colloquies, there's always something you're missing. But it seems to me like if I'm the trial judge,
and you're a defendant, and you're about to plead guilty to me, first-degree murder, and I'll tell you, the prosecution, go ahead and recite the facts of this case. And the prosecutor gets out there and says, he shot the victim in this case. I'm going to prove that he shot the victim in this case. What else does your client need to have?
Well, Judge, as you know, in our district, I'm assuming you guys do it the same way. What normally happens, and it normally happens in our district, is the prosecutor literally reads the indictment and says, this defendant is guilty of premeditated murder because he consciously formed the design to kill somebody, and then goes through the factual basis.
But the judge says the prosecutor said, recited the facts that your client was the person who shot the victim.
Again, and the defendant says that he was not the shooter, and even in the state's best case, in the best light of the state's case, there is evidence of a reflexive action or something that does not prove premeditated murder, that our client went up and shot somebody in cold blood.
Well, that's not really true either, because the medical examiner has this gun as being right on the head of the victim. It's not like it was. It's not like a shot that went off in the middle of a reflexive action. It's like, isn't it? What is your understanding? What the medical examiner?
Good point. That's the only evidence they have in
That's
this
pretty
case.
strong evidence.
Well, the trial court, even in its sentencing order, found that there was reasonable, when they were arguing CCP, when the judge didn't find CCP, they said that there was a reasonable hypothesis that this was an unplanned murder and it could have been an accident. And even if, when you read the sentencing transcript, the lead detective says, yeah, you know, that it's possible that this could have been an accident.
So let me ask, what is it that, assuming that this transcript only supports that your client understood that he was pleading guilty to felony, first-degree felony murder, so you're asking us to what? Go back and allow him to just plead to felony murder?
No, he would have to plead anew with the premeditated, with the premeditated first-degree murder. Under Gaddy,
He would have to what now?
you have to withdraw his plea.
To do what from there?
Allow him whether he wants to plea again, with hopefully this time an understanding of the nature and the elements of the offense, or let him go to trial.
But why? I guess, again, I'm trying. If he understood that he was guilty of felony murder, and why should he be able to withdraw his plea, since you have, I thought, we went over this, that either theory, felony murder or premeditated, supports first-degree murder and supports the death penalty.
Respectfully, because the U.S. Supreme Court says you cannot do that.
I don't think that's what Henderson says. Henderson was second-degree murder, where the intent element was important for second degree. First degree has two alternative theories, and I just not.
And also, Justice Perriente, Bradshaw v. Stump also says that if there's not a record of something, of a trial court referring to these elements, or the counsel affirming that these elements were read on the record, and the fact that the defendant understands this, it's a due process violation.
Are you saying that there is a case out of the U.S. Supreme Court that says that the elements of the offense must be read to the defendant on the record?
No.
Okay, I thought you just...
I said or affirmed by trial counsel that they were.
On the record in the plea colloquy, or somewhere after in post-conviction?
No, before. Let me
Isn't
clarify.
that the point, though, really, of why you should file a motion to withdraw the plea? And then you have an opportunity to have this kind of information on the record when you appeal it. And in this case, there was no motion to withdraw the plea, so we have no idea of really what went on
Well, unfortunately,
between
yeah.
the defendant and his lawyer.
I
correct?
wasn't trial counsel, so I couldn't, of course, but
Before you sit down, I want to ask you about the polygraph. If we were to state that there should be no per se rule, that polygraph results are inadmissible in a penalty phase, not a per se rule, that it's subject to reliability and the ability of the state to cross-examine.
Yes, Your Honor.
Since the judge in his sentencing order specifically said, I am not relying on whether Mr. Sanchez Torres is the shooter, in imposing the death penalty. And since this was a judge-only penalty phase and sentencing order, why under this circumstance wouldn't it be harmless beyond that?
Good question. I think if you look at the polygraph, and if we consider the polygraph, of course, it was a proffer, and it was a plus 12, which you already know, and the expert said that that was as good as it gets for a polygraph test, that this guy was not the shooter. It proves a lot more than just whether he was the shooter or not. If you look at the case, if you believe he was not the shooter, then he was also next to the car. He wasn't going out and planning this robbery or bopping somebody on the head and conspiring with this co-defendant. It also infers that there was one gun used and that this defendant did not know. So it goes to a lot more than just whether he was the shooter. And if you're looking at whether there was...
His statement that he participated in the acts of the robbery are refuted by the polygraph?
No, I'm saying, not refuted, but the polygraph certainly helps the fact that he didn't have as much responsibility in the armed robbery as the state was leading on.
But this judge, you're going to relative culpability, correct?
Correct.
Of course, the
And not lingering
co-defendant,
doubt, yeah.
there was a specific finding that he wasn't the shooter. So there's some question here, and your client did a 3-page statement where he said he was the shooter. But what I'm asking is, for this judge, in weighing it, he did not base his death penalty finding on whether or not this defendant was the shooter. He specifically said, I'm not considering that. So if he didn't consider it, why is it material to the judge that would require a resentencing?
Again, Judge, I don't want to waste all of my time, but it goes to a lot more than just whether he was the shooter. And
But you're not even alleging it should come in the guilt phase, and since he pled guilty, so, and you can, save your time for rebuttal if you.
thank you.
May it please the court, Assistant Attorney General Charmaine Millsaps representing the state. I would like to start at the very beginning of the plea.
Would you start, please, by keeping your volume of your voice up? So
Yes. At the very beginning of the plea colloquy, Assistant Public Defender Kate Bedell stated that she had met with Mr. Sanchez numerous times and discussed all his options with him numerous times. That's volume 9 at page 41. So we do know that this was not the first time, the plea colloquy was not the first time his attorney talked with him about entering a guilty plea.
And at the time he entered the guilty plea, what was the status of the other murder charge? Was he in prison for that, or had that trial already occurred?
The date of the sentence for the prior murder was December 11th, 2009. So, yes, because the plea here...
But he already was sentenced to life imprisonment without the possibility of parole for this prior violent felony.
Yes,
correct?
for the prior murder.
And the judge, and this is something, the judge in this colloquy said, you have a significant aggravating factor in this prior violent felony that would increase the likelihood that you're going to be subject to the death penalty. That was in the colloquy.
Yes, the judge told him that.
Okay. So, to me, that also really might be a question of why did he thought he had a good defense in this crime? Maybe he shouldn't have pled, but that's not before us today. But it does seem that the colloquy was a little bit confusing in that the judge keeps on talking about premeditated murder, and yet it looks like what the defendant thought was the crime that he would be guilty of was felony murder. So explain how we sort of, and we certainly know the elements of the crimes of premeditated murder and felony murder were not explained during this colloquy.
Oh, yes, no, they were not. But, Your Honor, he's really asking for more. The requirement, the constitutional requirement is nature of the charges, not elements. But he's asking for more than elements, Your Honor. He wants the judge to also give a definition, the legal definition of premeditation. In other words, he wants large parts of the jury instructions read to a defendant, and if they're not, their plea is involuntary. He's not just asking for elements,
But
Your
you
Honor.
agree that what Justice Labarga said would have obviated this whole problem if the judge says you're pleading guilty first-degree murder. You don't have to say you're pleading guilty to first-degree premeditated, and first-degree murder can be proved either by premeditated murder or felony murder. You understand that. That would sort of have obviated all of this, what we're doing today.
Well, let me
Maybe
let me
not,
tell
but
you
as
what
far
I
as
think
from our
really
point of
went
view.
on. Okay, first of all, he did more than admit to being a participant for felony murder. He admitted that there was a plan. There was a plan to rob. He admitted that to the
No,
judge.
but you agree, the judge never said you're pleading guilty to both premeditated murder and felony murder.
I think by the end, yes, he did, because then they started talking about count 2, which was the armed robbery
He
count.
didn't use the
because-
words.
No,
He
he-
used the two different crimes, but did not use those words.
No, he did not.
Okay.
No, he did
And
not.
he was separately pleading to armed robbery, correct?
He was. It's count
but
2.
he
And
never
part of the
put-
plea colloquy is a plea to that count 2. Prosecutor pipes up, we need to talk about count 2, the armed robbery as well. But let me explain to you why I think what's going on here, really. What's going on here is the state believes that he was the shooter, so as part of its factual basis, understand something, Your Honor. We think we can prove premeditated murder, and we think we can clearly prove he's the actual shooter to a jury, okay? So the defendant doesn't like that. He's really, his misunderstanding is based on his own insistence that he's not the shooter. But that's not what plea colloquies are about, Your
Well,
Honor.
does that lead into one of his arguments is that this record, due to the nature of the pleadings filed, particularly the motions for rehearing, that the Edmund Tyson discussion reflects that all this goes hand in hand. It shows that this lawyer was under the impression that if he's not the shooter, then the death penalty's off the table. I mean, that seems to be his whole, that really, when you take this apart, that's where he seems to be headed with all of this.
Now, Your Honor, I do think on the Edmund Tyson, we would have needed a motion to withdraw under 3.170L,
I mean,
so I
isn't
can
that really
talk
where
to this lawyer.
As we look at this, this whole scene, and he's saying, we don't know, and then he's saying what his lawyer said, what he didn't say. What effect do these pleadings have that are of record that do seem to indicate that?
But, Your Honor, we have to have the lawyer's explanation of what she
Well, I
told him and
understand.
what's his
I'm just asking you a
understanding.
question. Do those motions sort of reflect, or do they not reflect a misunderstanding of the Edmund Tyson analysis?
Well, no, I'm not sure they do, but, Your
Okay,
Honor,
all
we
right, well, that's
can't
fair.
do it.
So we don't have that in this record then. It doesn't show it clearly. So that's just an argument without a factual basis, then, is what you're saying.
Yeah, yes, and if he
Okay.
wants to raise it in post-conviction as a claim of ineffective assistance of counsel, that the public defender, Kate Bedell, and his other public defender, he had 2 death certified, he actually had more, but he had 2 death certified public defenders. We need to call them both, ask them their understanding of Edmund Tyson, and incidentally, Your Honor, he's doing it again with Edmund Tyson.
I
He's
understand.
the actual shooter, okay? And that's what
I
the state's
understand
going to
he's a-
prove. And we have more than just the medical examiner saying the contact wound. When this defendant, not only does he admit to being the shooter in his written statement, but when this defendant reenacts the crime, he puts the gun right under the left eye of the victim, which is exactly where this victim was shot. Thomas, this was a dark night. Thomas was too far away. He would not know that detail. We have lots to prove he's the actual shooter.
Where is it that he reenacted the crime?
There's a videotape reenacted. That's
I mean, where does
going
he-
a little bit. He makes motions. Okay.
In other words, he
makes
was able
motions.
to show exactly where the shot was? Is that what you're saying?
Yes, he makes a motion like this. Okay, and that motion.
Isn't that possible, even if he was not the shooter? I mean, he obviously was there. He admits to participation in the robbery. I mean,
No,
wouldn't he
because-
be able to see what was going on?
No, because the co-defendant Thomas is in the car. which is a few houses away, and it's dark and there's a bush in between. No, Your Honor, we don't. No, Your Honor,
How do we,
we don't
know
really.
that for a fact?
I know that for a fact. I was just
No,
about to
no,
say
I mean,
months.
how do we know
You
that
do.
for a
You do
fact?
not, because you do not have the entire Thomas record. I do.
But you're not saying that the state sought first-degree murder for the co-defendant when the co-defendant was in a car several blocks away?
No, houses, not blocks, and it was part of a plan.
To kill or rob? So
We think it was part of a plan. The co-defendant said that he knew that Sanchez was going to shoot the victim. So we think it wasn't a plan to kill.
that's what Thomas said in his trial?
Thomas said that he also confessed. He also gave us a confession. But it was all that Sanchez got out of the car and went a few houses down, and Sanchez had the gun, and that he hopped in the car. He knew there was going to be, he said he knew somebody was going to be hurt. And the detective interrupts him. Incidentally, this is not in your record, Your Honor. This is in Thomas' record. And he says, Thomas says that, no, to the detective, no, I'm not saying I just knew that somebody was going to be robbed. I knew that somebody was going to be shot. So, yes, Your Honor, on those facts, we saw it for, first-degree murder on the co-defendant, too, because that's bold as brass felony murder. That is classic felony murder. And now, that conviction has been affirmed, Your Honor, but they're going back for a Miller resentencing because Thomas was 17 at the time of this crime. But the conviction has been affirmed. Understand, Your Honor, what he's really doing is this, and he's doing it with Edmund Tyson, with both the plea and Edmund Tyson. What he's saying is, I don't agree with the state's position that he's the shooter. Well, Your Honor, you still enter a plea, and your plea's still voluntary. Because guess what? The state's telling you, you may not like it, but we can prove it. And that's really what's going on here, both voluntariness of the plea and Edmund Tyson. But I don't think we get anywhere near Edmund Tyson. First of all, it's pretty hard to argue that Edmund Tyson would make this plea involuntary when the judge, understand what the judge did. The judge remained neutral. He didn't find he was the shooter, but he did not find he was not the shooter. He just said, I'm not going to find that he's the shooter. We have a non-finding of triggerman status. Now, oddly enough, in the co-defendant's case, he found that the co-defendant was not the shooter as part of the Miller litigation. So, but anyway, he's allowed to do that. He said, I'm not going to find that Sanchez is the shooter, and I'm not going to find that he's not. But as part of that discussion, he does lay out how strong the state's evidence is that his own, he said, the trial judge says things like his own confession undermines his credibility about not being the shooter. The state's medical examiner about the details, knowing the details of where the victim was shot when the co-defendant, because it was dark and away. So, Your Honor, this judge, why he does not technically make a finding that he's, and remains neutral on whether he is the shooter or not, he openly, that discussion, if you read that, reads like both, this trial judge realizes the state's going to be able to prove this if we get in front of a jury. And that's often exactly why defendants enter pleas.
When the plea is given like this, what, for the defendant to properly waive or to waive trial and enter into a plea, do they need to understand what the state must prove in either the felony murder or premeditated first-degree murder? What degree of understanding does a defendant have to have of the state's burden of proof?
I think he has to have only a general nature of the charges. Your rule requires that. The federal rule requires that. Nobody talks about you have to go down the elements. But, Your Honor, he's even asking for more than that. First of all, reading the elements of premeditated murder usually are, the elements themselves are very, very small. Victim is dead. You shot the victim, okay? What he's really saying is, I want you to explain to me.
Well, with the premeditated, I mean, you still got to talk about, if you're talking about the elements of premeditated murder, you still got to have the intent element, which is what they allege is missing in this plea colloquy.
Right, but in the elements, we just say the element is, and there was a premeditated design to kill, okay? It's in the next couple of paragraphs where we then fully, he really wants the jury instructions read, where we fully explain premeditation. We don't, the element does not contain a definition of premeditation. It's the paragraphs later, okay? So he's asking for more than elements. And no, Your Honor, there's no, Your Honor, I couldn't find a single case from anywhere, much less a United States Supreme Court, much less from this court, saying that, I would like to talk about Perry, because he cites Perry. You in Perry say elements, but you use elements in the sense of element of voluntariness. You do not say that. There is no case from this court either.
Do we have, since the death penalty cases and first-degree murder, obviously, of all the kinds of pleas that you might take as a trial judge, sort of up there, is there a standard or a model plea colloquy that has been adopted? Do you know, either in rules or anything that materials provided to trial judges?
Your Honor, I'm not aware. Yes, there are model plea colloquies available.
Because it would seem,
but we
again,
do not have one as part of our rule that I know of.
But the fact that the judge is saying you're pleading guilty to, you agree, he said, first-degree premeditated murder. Then we have, at the end, we have the factual basis being felony murder. Or do you say the state's factual basis were both?
The state's factual basis is for both, Your Honor.
Okay.
Understand something. We think he's the shooter. The judge may not. The judge even basically in his discussion admits the state's going to be able to prove this.
That's, you say, at the time of the plea colloquy.
Yes, because that's what we got in a big fight about. And that's really where he's getting this. Your Honor, the state's position was, and remains, he's the shooter. All right? We said that during the plea colloquy. He wants to say, no, he's not.
Well, because there was the point in the plea colloquy when he insists he's not the shooter, and the judge says, well, if you're not going to agree you're the shooter, I can't take this plea, correct? That's when the judges, that's when the state kind of said, no, judge, you still can take this plea even though he doesn't agree he's the shooter. Isn't that what happened?
Yes, Your Honor. Yes,
so the
but Your
judge
Honor,
had a misunderstanding, too, that he had to be, at some point, that he had to be the shooter in order for him to accept a plea to first-degree premeditated murder.
Here, think of Alford, please, Your Honor, where it's in my best interest to enter a plea. They even assert true innocence, but it's in their best interest to assert a plea. Now, what he's doing is he's fighting with the state about a fact that they can prove, but that doesn't make your plea involuntary. Okay? That's that he wants to fight. He wants to somehow bind us with his own assertion that he's not the shooter. And he's allowed to enter a plea, understanding that the state believes he is the shooter, and the state believes it's going to be, quite frankly, easy as pie for us to prove it to a jury that he's the shooter. So my other problem with all this premeditation in Edmund Tyson is it has no real connection to the state's case. It's his theory. It's not ours. And when you plea, you're pleading to the state's case because that's the factual basis. We have the prosecutor give the factual basis for a reason. That's what the state says it can prove. And that's what the state can prove here.
This plea, these proceedings, was it scheduled to be a plea colloquy, a plea proceeding, or was it like something else and the defense counsel walked up and says, my client intends to plead guilty today, Judge, and caught everybody by surprise?
No, Your Honor, there's nothing in it. I
It
got
was
no
scheduled for a
sense
plea?
of surprise. I got no sense of surprise. And they had discussed it. She literally starts out, we've discussed it numerous times, and this is what we have decided to do, and I've had time to talk to him and his mother. Your Honor, there's no,
Well,
I got
I mean,
not the
so
slightest hint.
I guess what I'm getting at is, I just read through the transcript of the colloquy where the prosecutor gave the court the factual basis, and it just seems like he or she, I don't know who, it's Mr. Nelson, it seems like he's just winging it. There was no preparation. It would seem to me that if he knew there was a plea colloquy coming, and it's a first-degree murder case where the state's seeking death, where it's going to be reviewed by this court and who knows what else, what other courts, you would have some kind of written down statement on facts that you're going to give to the judge. These are the facts that we believe we will be able to prove beyond a reasonable doubt before a jury judge. Bang, bang, bang. And he is just like whatever happens to Flash, he's coming out of his mouth.
Your Honor, it may be true in the sense it may have been somewhat of a surprise to the prosecutor. I took your question to mean was it a surprise to defense counsel, some last-minute decision on their part? And that's clearly no. The prosecutor, Your Honor, for all I know, he was busy that morning.
It was first-degree murder. He's seeking death. I mean, you spent 30 minutes in your office writing down facts that, he's challenging. He's saying that he didn't do the shooting. He wants him to plead guilty to that. It just seems to me like in these type of cases, it would save everybody in the system. I mean, if it was just done right. And, again, you can read through it, and he's going on basically saying things like in the admission that he shot him, he gives facts and only the perpetrators would know. Okay, tell us what those facts are. I'll put this on the record. That would be helpful, wouldn't you think, as far as your job is concerned?
Yes, Your Honor, it would. And incidentally, I agree with you that unless you've read the Thomas record, some of what's going on here, because this judge presided over both trials, a lot of their knowledge is collective, and you all don't have access to that knowledge.
Well, at the time of the plea colloquy, the Thomas trial had not taken place.
No, Your Honor, but
So Justice Labarga is asking you about the plea colloquy, not what might have happened some other time. So nothing about the Thomas case has not been tried.
no, it hadn't been tried, but Your Honor, the depots and everything like that had.
Well, the judges was told about the depositions?
No, I don't know that he was told about the depositions. Your Honor, obviously, I would have liked a more complete factual basis because if this court understood more of what was going on, I think it would be clearer to you what he's really doing.
Well, it also, frankly, it would be helpful if it was clearer, because then we wouldn't be talking about we'll do this in post-conviction. I mean, we don't want to have to encourage these issues to be litigated in post-conviction, and it's frustrating because when the judge starts out saying, you're pleading guilty to first-degree premeditated murder, when clearly what's going to happen is he's pleading guilty based on his knowledge that he would be guilty of felony murder for sure, because the defense attorney says, my client has always maintained that he's not the shooter. So we've got to sort of look at this whole colloquy to piece it together, but as you have, I think, agreed, this isn't a model colloquy that helps us in resolving this issue for all time with this defendant.
No, it's not a model plea colloquy, but Your Honor, now, parts of this, no matter how good the plea colloquy would not be proper here. Some of these claims are just simply have to be litigated in post-conviction because defense counsel must tell us what the discussions were. So some of this, the general voluntariness of the plea, yes, you can litigate here, but her understanding, the understandings of Edmund Tyson's and what she told him and that kind of stuff, unless he files, and incidentally, he could even do it here if he wanted to, but he needs to file a motion to withdraw the plea after sentencing, a 3.170L motion to do that. We need counsel's testimony before we can do that. If there are no further questions.
I want to ask a question about the polygraph. Did the trial court exclude the polygraph?
Yes, Your Honor. He let them proffer it. Remember, this whole thing was a bench trial, okay? The whole penalty phase was a bench trial. And in multiple stages because they wanted the Thomas trial to come in between. So the state put on its penalty phase case. Then we waited for Thomas in case there was a finding of shooter, non-shooter. And then we went on. And as part of that, Your Honor, he let him call the polygraph examiner, Dutchman, I'm going to mispronounce it horribly, and testify fully. So it was a proffer in the technical sense, but
How
the
is the-
full proffer.
I understand about the testimony coming in. In what way did the trial court exclude it? Was an order entered? Did he say, I'm excluding this? How is that manifested in the record?
In his sentencing order, Your Honor.
I've read the sentencing order.
That's how they're getting excluded. I refuse, I'm not going to consider the polygraph. As part of the
He said, but he refers to it not being probative.
That's what they're talking about. That's what they're talking about. It's not probative. I'm not going to,
But that's not saying it's excluded.
well, under our statute, Your Honor, if something's not probative, a judge is allowed to not consider it. That's what they're saying. He refused to consider it in the sentencing order.
But that doesn't mean it wasn't. He considers it. He's got to consider it to determine whether it's probative.
Yeah,
and then he can
absolutely.
discredit it or not credit it. But it seems like to me that what's going on here is not the exclusion of evidence, but the decision by the trial court to not credit the evidence. That's a different matter than excluding it, isn't it?
I do agree with that, Your Honor. That's a different matter than excluding, but he does, the trial judge does say, I find this not to be probative. I think those are exact words, and those are the words of the statute as well. Your Honor, don't misunderstand that judges do have the power, whether it happened here or not. Judges do have the power to exclude evidence in the penalty phase that they do not believe is probative.
Well, he did cite to Perry and Christopher, which are two cases from this court, the
saying-
precedent says it can't be considered.
That's right. He did cite to them.
So are you saying that the judge actually thought he had discretion to consider it or not?
Well, Your Honor, now, if you ask, the sentencing order is not a model of clarity. I
What
think the
happened
judge
when
excluded
it was
it.
proffered? He said, what did he say at the time that the testimony was going to be proffered, which means I'm not going to consider it?
Well, he said, I'll let you put it on as a proffer.
Well,
It was
why did
clearly
he say he
labeled.
wasn't going to hear the testimony?
Oh, now, Your Honor, there were memos back and forth. They filed a memo saying we want to present polygraph. The state filed a counter memo.
Saying what?
Saying under Fry and that it should be excluded, and we cited Fry. So these were memos. This judge is doing this on written memos, one from defense lawyer as seeking to admit the polygraph, and one from the state seeking to exclude the polygraph, citing Christopher, Perry, and making a Fry argument. That's what we argued in our memos. So we're doing.
The law is that in the penalty phase, that the rules of evidence and everything else is relaxed. We allow hearsay. We allow all these other things in. So in excluding the polygraph, the judge, would you agree the judge necessarily had to do so on the basis that we have a per se rule, that we just don't allow them in?
Well, now, the language of the statute, our penalty phase statute that relaxes the rules, says that evidence is admissible, even though it normally would be inadmissible, if it's deemed relevant by the trial court and to have probative value by the trial court. And, Your Honor,
And what was the basis for the trial judge's exclusion of the polygraph? Because it wasn't reliable to him, or?
No, Your Honor, quite frankly, I think he followed Perry.
Okay, so we appreciate that. I mean, it wasn't a way, and so the state is advocating for a continuation of a per se rule.
Yes, Your Honor.
Okay.
Yes, yes. And we think that yes, we do not think you should recede at all from Perry. And incidentally, Your Honor, I know why he disclaimed any reliance on residual doubt. When he says it goes to more than the shooter, that's striking me as residual doubt, at least as to premeditation. So I'm hearing some residual doubt. But let's just take residual doubt off the table. Your Honor, relative culpability. Evidence must be reliable even in the penalty phase. The exact reasons the United States Supreme Court gave in its Schaefer case, okay, were twofold. Not only do we think abstractly that polygraphs, that there's a big debate whether they're any more reliable than tossing a coin to 90%, but secondly, because of countermeasures. Defendants can take countermeasures. Even if we could ever resolve whether polygraphs are abstractly reliable, defendants can engage in techniques making them once again, unreliable.
But we do have, since we decided those cases in the, whenever, 1980, several state Supreme Courts have held that the polygraph examinations are admissible in the sentencing phase. Washington Supreme Court, the Georgia Supreme Court, among others. And so it seems that if you have it subject to the restriction that this has to be a reliable polygraph test, and the state has an opportunity to cross-examine, then it would seem that that would be one more piece of, if comparative fault, relative culpability is an issue. Now, again, I think the fact here is that this judge seemed to make a big deal of saying, I'm not going to say who the shooter is. And so I think we have to take him at his word, so it doesn't seem like it would be harmful error in this case. But, and I'm assuming you would agree with that as a fallback.
Yes, absolutely, and that's what I argued. But, Your Honor, I don't think, I disagree with the beginning part of your sentence. Let's not make it sound
Well, you don't disagree that other state Supreme Courts have allowed it in the penalty phase?
Some have not. Louisiana, I cited several cases where...
What other Supreme Court other than Louisiana?
Louisiana has excluded it. One of the federal circuits have excluded it.
What other state Supreme Courts other
Well, Louisiana's the only other one I know, but that's 2-1, Your Honor. And several of these, first of all, the Haidt case, he's using it as residual doubt in Haidt because there's no co-defendant. So that's clearly improper. So you should not rely on the Georgia Supreme Court because they're doing that as residual doubt. Now, Haidt had no co-defendant. So now Roop, which is a Ninth Circuit case that he relied on, that was a relative culpability, but Roop was decided before Schaefer, Your Honor. Really, since Schaefer, the federal courts have not been admitting these in penalty phases because they followed the logic of Schaefer. Those two problems of reliability are present in a penalty phase just as much as they're present in a guilt phase. So I do not want to leave this court with the impression that there's some trend that way. They may have started down that trend, but Schaefer pretty much put an end to that trend because most people recognize that the United States Supreme Court logic applies just as much, the unreliability applies just as much to the penalty phase. And you certainly should not follow the Georgia Supreme Court because that's clear. First of all, their statute's not like ours. It doesn't have the limiting language of relevant and probative.
If you would sum up, you're out of time.
Yes. All right. So, no, we do think you should continue to follow Perry. Thank you very much.
Whittle?
Your Honors, in the argument before the court today, the state of Florida sat here and told you and wanted the court to look at a specific quote from defense counsel when the plea dialogue between the court and Mr. Hector Sanchez Torres began. And that quote essentially was that Ms. Bedell, the attorney on the record that was speaking on behalf of Mr. Torres, mentioned that she had gone over all the options. What the state is having this court do is infer from that word options that the defendant had a complete understanding of everything that was happening to him in court and everything that would happen through the plea dialogue. If we're going to point out particular quotes in the actual plea dialogue, one thing that I would also like to point out is Mr. Nelson's quote at the very beginning of the plea dialogue. He was representing the state of Florida, who simply sat there and told the court, Judge, before we take this plea, we have to make sure that this plea is voluntarily entered. It was of great concern to the state at the beginning of the plea, probably because of Mr. Sanchez Torres' position that he was not the shooter, that the court went through great pains to make sure.
When counsel mentioned that she had explained all options to your client, and you're arguing that that's not enough, what should she have said? What she should have gone through every single options: premeditated murder, felony murder, so on and on.
Well, I don't know that.
How specific does she have to be?
And that's a good question, Your Honor. I don't think we're proposing to the court that there needs to be, as the court used earlier, some magic words that need to be uttered, but there does need to be something on the record
that clearly demonstrates in one fashion or another that the defendant was made aware not only of just the general nature of the charges the state tries to argue, but that he's on real notice of what is happening to him, which includes the nature and the elements.
So it has to be either the lawyer is going to say it, as in this case, when the lawyer is the one who says that, my client is going to plead guilty. So you're really asking that either the lawyer say, I explained to him the differences between felony murder and premeditated murder, or you're saying that the judge has to say it. So you're saying that either way, it's got to be on the record of the plea?
I would agree with that. There has to be some indicia on the record that the defendant understood what he was pleading to. The core element of any plea is essentially that there's an understanding between the defendant and the court in relation to the defendant's conduct and how that relates to the elements of the charge.
Okay, so it still all comes back in my mind to the fact that it is clear to me on this plea colloquy that the defendant understood he was pleading at least to first-degree felony murder. Would you agree to that?
I would agree that there is enough in the defendant's statement that the court could interpret that he may have understood that he was pleading to felony
Okay,
murder.
so then we get back to Justice Pariente's question. If that's the case, then why would we allow him at this juncture to withdraw his plea? Well, I guess he's not asking to withdraw, but for us to find that his plea was involuntary.
If I can answer that twofold, in response to, I would agree with the court that if that was the only confusion within the plea dialogue.
Well, that's not confusion, because he admits, I was there, I participated in this robbery, therefore I'm responsible for the murder also. In essence, that's what he said.
Even if this court agrees with the cases that we cite in our brief, Henderson, Bradshaw v. Stumpf, Gaddy, those cases stand for the totality. The circumstances have to be reviewed to determine the voluntariness. Even in...
Counsel, would we be here had the judge sentenced him to life?
I'm sorry, Your Honor, I didn't...
Would we be here if the judge had sentenced him to life?
Possibly. I understand the court's question that if he had gotten the relief that perhaps he was seeking, will we have this issue? But it doesn't change the fact that there's clear, that argument is that it's clear on the record that he still didn't know what was going on.
He didn't know he could be sentenced to death?
And this gets a little bit into the Emmett Tyson issue that we had argued, in the sense that, yeah, he was on notice that he could get death as a possible sentence.
Okay.
But the dialogue between the court and the defendant regarding the possibility of death actually is in direct relation, the bulk of that discussion, in direct relation to the fact of whether he was the shooter or not.
Well, I thought the judge told him that it didn't matter whether you were the shooter or not.
The way
and also his attorney said in the opening statement that, we're aware that if whether or not he was a shooter, he's still susceptible to death. So,
Our argument is essentially that the way that the court instructed him, the court implied one thing, and the court basically told Mr. Sanchez Torres that, listen, I understand you're claiming that you're not the shooter, but if I make a finding that you are, I can still give you death despite your claims that you're not.
That's not what he said. You need to reread the quote. And, it's not if.
Judge, but what it also implies, or what the court doesn't specifically tell Mr. Sanchez Torres, is that if he can still sentence him to death if he does not find that he's the shooter. And because of that issue, we feel that creates essentially another atmosphere of confusion. And, Your Honors, I see that my time is up. Thank you.
Thank you for your arguments. At this time, the court will take its morning recess for 10 minutes.
Supreme Court of Florida is now in session. Please be seated.
Our next case for the day is State of Florida versus Whittle. You may begin.
Good morning, Your Honor. May it please the court. I'm Carol Ditmar from the Attorney General's office representing the appellant in this case, the state of Florida. Mr. Whittle committed a very brutal double murder in the end of 1996. He was tried and convicted towards the end of 1998 and was given 2 death sentences at that time for both victims. When this court had the case on direct appeal, the court determined that the sentencing order had not sufficiently evaluated the mitigating evidence that had been presented, and this court remanded for the writing of a new sentencing order which adequately addressed the mitigation. Unfortunately, the trial judge who had conducted the trial and generated the first sentencing order had retired and was no longer available to come back. So in June of 2004, the case having been reassigned to a new judge, had an entirely new resentencing proceeding where a new jury was impaneled, new jury recommendations were taken, and a new sentencing order was entered, which this court then affirmed. The evidence
let me ask you, from the time that we ordered a new trial, we said it should be remanded for resentencing, but the judge was not available. How much time between then and when the actual penalty phase started? Was it a short, because
it was a couple of years.
It was a couple of years. So could you, in that context, explain what, and you're in a unique position. I don't think I've seen you on this side maybe ever.
Very different, yes.
Very different. You're appealing the judge's grant of a new penalty phase.
Yes.
In the 2-year period, what did Mr.
Mr. Colon. Well,
Colon. What did he do to prepare himself for the new penalty phase? It's sort of like, here's this chance I now have that I didn't think I was going to have to convince the jury that this defendant should get life.
Second shot. Right.
What did he do?
The things that he remembered that he fully familiarized himself with the record. He reread the entire trial and penalty phase. He had Mr. Whittle again evaluated by Dr. D, who had testified at the initial penalty phase. He had him retransported and had another evaluation set up. He touched base with the witnesses he had previously presented, and he
actually talked to those witnesses. What did you say he did? What with those witnesses?
Well, he touched base with them at different times. It is very unfortunate that he did not have a good memory in this case, and he is not a good note taker.
When we say he doesn't have a good memory, we have a lot of cases where it's like 20 years, but this resentencing was when?
2004, and the evidentiary hearing was 2011.
And he didn't keep notes and time records of what he did?
Not very well. No, Mr. Colon was very disorganized. He testified that even with his billing with the court, he frequently underbilled because he didn't keep good track of his records, and he just did not have
found,
that
and this is on the deficiency prong, and prejudice
Yes.
may be a different issue, that essentially, even though he had gotten this mitigation specialist 3 days into the first case,
Right, in
and
1998.
and both Dr. D and the mitigation specialist said there's a lot here
Right.
that we've got to do, and she gathered the records from his earlier years. He just decided not to pursue this mitigation specialist. Even though Dr. D said there's a wealth of information here, essentially did nothing.
Well, I think he felt like all that had been done back in 1998. And yes, he was scrambling to put on the penalty
Well, how
phase in
was it done in
1998.
98?
But the trial was a month. So that when you say, well, it was the beginning of trial when the mitigation specialists come on. Dr. D had been on before then. And Dr. D was the one that really, I think, put the mitigation case together.
Well, since we're dealing, again, not with the judge having denied the motion, the judge made some findings about how much he did and didn't do, and aren't those findings, because he's looking at the credibility of the defense lawyer and everyone else that testified over this 9-day period, we defer to the credibility determinations. that he made. And what I'm felt from reading that whole, order and everything else is that he sort of thought that this defense lawyer essentially went through motions but didn't really
do anything. Well, and that may be the way the testimony came across to this judge. My focus today, I was intending to focus strictly on the prejudice, because I think we do have some clear legal errors committed with the prejudice. And we do not have a lot of factual findings. The findings that we do have on deficient performance is that the judge found that when it came back in 2004 that Mr. Colon did not rehire a mitigation specialist, and that he did not personally travel or get a mitigation specialist to travel to North Carolina and Michigan and Pennsylvania and places where Mr. Whittle had lived. So he noted those are the specific facts that he makes those findings, that those were not done, and that's where he finds the deficient performance. He also says there was not sufficient effort made to go out and consult with experts. So those are the specific deficiencies that he finds.
And were those then addressed in the evidentiary hearing? I mean, did the post-conviction counsel or investigator go out to North Carolina, these places that the judge talks about in the order?
Certainly, but the judge never identifies in the order what's really compelling that they find that he didn't already have in 1998. Because even though they didn't go there personally, they had the aunt and they had the sister and they had the father who all lived in these places.
The father testified falsely.
Well, he testified, again, we don't have that finding from Judge Hunter. We have his testimony, which is, you read it and it's questionable, and you're thinking the jury probably has questions about this man testifying before him, but you have his testimony, again, along with the sisters and the aunts, and the big difference in 2004, frankly, was that Mr. Whittle testified. He had not testified at the initial penalty phase in 1998. And one of the things that Gil Colon said was that by the time the resentencing came back, because he met with him frequently, he said, by the time the case came back in 2004, I had established a rapport with Mr. Whittle, and even though we had always worked well together back in 1998, he was not that comfortable. By the time it got to 2004, Mr. Whittle was comfortable testifying. No, I can't say comfortable. He was agreeable to testifying, and he did testify, and Mr. Colon thought that was a very good thing that the defense had done, and was a very strong factor, and certainly they got a more favorable jury recommendation in 2004. So it was a different case in that sense, in a different light, but it's a lot of the same evidence. And even though a lot of this did come out in 1998, but I think it's fleshed out even more in 2004. But it is comparable to the case that was put on. I think where this case stands out among cases where we have an issue of ineffective assistance of counsel is that typically when you have that finding, you look at the defendant as he's been portrayed in post-conviction, and you have a completely different picture of the defendant than what the jury had at the resentencing or at the initial penalty phase. And in this case, if you look at the defendant and you look at the wealth of mitigation that was presented, certainly in post-conviction, but also at the resentencing, and for that matter, even back in 1998, and it's the same picture of the defendant. The picture really doesn't change.
Let me ask you about Dr. D. Dr. D was the expert.
Yes.
Now, there's a statement in the record where the defense lawyer says, we tried to have him evaluated. Are you familiar with that? Do you know what that? The person he was evaluated by was Dr. D?
Well, initially he was evaluated by Dr. McLean. And no, this was back in 1998. He was
so he's referring to
having,
having, but he was cooperative.
Yes.
With Dr. D. Now, but Dr. D, when he testified, Dr. D said he really didn't know how the crime was committed, and he couldn't relate the mitigation he was talking about to the crime. What is it? Could you explain that? Because that concerns me. In other words, you can have a mental health expert get on, but if he hasn't been properly prepped with the background information and the real dynamics of the family and the alcoholism and the addiction.
Dr. D was certainly familiar very much with the dynamics of the family, with the role of alcohol, both at the time of the crime and Mr. Whittle's history of alcohol use and alcoholism in the family. The background, he was very familiar with the factual background. He talked about what a horrendous background it was, and Dr. D had a unique perspective because I know this court is very familiar with Dr. D, but for many years, he was part of the child protection team in Polk County, and he saw many, many, many cases of very severe abuse and neglect. And he talked about having that background and looking at this case, and he said this was some of the most severe neglect and abandonment and rejection that this child experienced than anyone has ever, than cases that he'd seen in all his years doing precisely that work. So that was very powerful mitigation to come in. And when he talks about not being able to explain the crime, what he's saying, Your Honor, is that this crime is so completely out of character for Mr. Whittle. It is so completely inconsistent with his life history, his life story, where he had overcome this neglect and abuse and abandonment and rejection, and he somehow had overcome it. He'd moved to Florida. He was trying to put a life together with his sister and his girlfriend, and he was struggling with jobs, but he was being productive. He was a good citizen. He was not violent. He was basically a good guy, and that's where Dee says the real disconnect is between Mr. Whittle's life and the murder. He says, really, you could expect how someone like that, from that background, would come out and not be a normal person, a good guy. But he says in this case, Mr. Whittle was that good guy. He really had overcome it.
Another area of concern, during the first penalty phase,
Yes.
Did he hire a mitigation specialist?
He did. At the very end, Tony Maloney came on. She had been working with the public defender's office. It's not clear in the record at what point she went out on her own, but she was working with Dr. D, basically putting together this whole...
This is the first...
Yes, back in 1998. Yes, now, Dr. D testified also in 1998 about the history, the background.
The instant penalty phase that we hear on,
yes.
Was there a mitigation specialist hired?
She did not know. She did not come back into the case when the case was remanded because Gil Colon felt like he really had the investigation completed, and he was interested in putting on a very similar case and just trying to add, he said, of course I wanted to find more, and of course I tried to find more. He couldn't be specific about what he had done.
Given the fact that it didn't work the first time around, don't you think perhaps the starting point the second time would have been with a mitigation specialist again to structure and plan his penalty phase as a starting point?
He certainly had a much more favorable conclusion the second time around, and I think he did do some different things with his strategy by having Mr. Whittle testify. I don't know that, because if what we see in post-conviction is what he could have done if he had brought in a mitigation specialist at that time, it's still really the same evidence and the same testimony that we had in resentencing, because the primary background testimony comes from the dad and the sister and the aunt, and of course Mr. Whittle himself.
To what extent do they address the deaf culture?
I'm sorry,
To what extent did they address the deaf culture?
They addressed the fact that his parents were both deaf, and Dr. D talked about it extensively. He had
first
read
trial,
the
second
first
trial?
Yes, in 1998 and in 2004. D testified extensively about him being a child with deaf parents and the impact that would have on his growing up, how he would be given responsibilities, parenting responsibilities that he wasn't ready to accept.
I thought that Dr. D didn't even know the parents were deaf until, and it wasn't in his report, until after Tony Maloney was hired and told him, and both Tony Maloney and Dr. D said there is a lot of information here that needs to be pursued.
Yes, but they did that. You're talking about Dr. D saying there had to be a lot of things. Dr. D had died before the post-conviction, so he did not come in post-conviction. It's not like he came back in post-conviction and said, wow, if I'd only known this guy had deaf parents, or if I'd only known about this. He knew about everything. And there's a conflict in the record as to whether it was Tony Maloney who discovered that his parents were deaf or whether it was Dr. D, because when Dr. D testified in 2004, his testimony was, at one point he was interviewing Mr. Whittle, and he noticed him using his hands, and so when he started talking to him about that, he comes out and he reveals that both of his parents are deaf. And he said, at that point, I had no idea. And this wasn't the first time I've interviewed him. I'd interviewed him several times. In fact, what Dr. D did, and he explained this in 2004, he initially gave Mr. Whittle an MMPI, a personality test. And he did not understand why Mr. Whittle did so poorly on the MMPI. But he explained to the jury, once I found out that he was raised in an environment where his parents were deaf, it made perfect sense because this has such an impact on their communication skills, on his ability to express himself. He said, of course the MMPI isn't going to work. And of course, he says, what it shows is he's psychotic. And we know for a fact he's not psychotic. Now, the interesting thing about the post-conviction experts, they don't do any mental health testing at all. They don't do any kind of they don't find any type of mental illness or mental disorders, and they don't talk about any kind of mental health issues. They're still talking about all the background issues. They're talking about the family, and they're talking about the abandonment and the rejection and the neglect. And it's the same three themes, basically: the alcohol use, the horrible childhood, and the being a child of deaf parents. The same three themes that run through the 2004 resentencing are the same three themes that run through the post-conviction evidentiary hearing.
Could you tell me what, if anything different came out in the post-conviction hearing that did not come out in today's hearing that would point to a deficiency or a prejudice?
Well, Dr. Marcus was an expert who came in specifically as they were referred to as a CODA expert, a child of deaf adults expert.
Well.
But his testimony was similar to what Dr. D had said.
Right. There was basically nothing different, though.
From my perspective, there was very little different. They did talk more about multi-generational family history, talking about the great-great-great-grandparents. Right. There was some discussion about that, which post-conviction was able to develop. That even the family didn't even, they came and testified, we didn't even know about this family history. It really was developed for his post-conviction case. But in terms of looking at the statutory aggravating and mitigating factors, which is what we're supposed to do for prejudice, you're supposed to, there's an abundance of case law about how we assess prejudice. We look at the mitigation.
Could I ask you a question? You're going really fast.
I'm sorry. There's a lot of stuff here.
Well, I understand, but about the deaf culture problem, I mean, did I just understand you to say that the family did not know to communicate this at the time of the second penalty phase?
No, everybody knew that. Back in 1998, everybody knew that his parents...
What did you just say about the family didn't know about the deaf?
I'm sorry, Your Honor, I don't...
Okay, maybe I misheard. Okay.
I thought you were talking about multi-generational.
About the great-great-grandparents. I thought you were saying they didn't know about that.
I'm just talking about their family, the family history in terms of, you know, the husband left the wife, and there was marital strife, and there was domestic violence, and there was alcoholism, and I'm saying that remote family history was not something that the mom, the sister, the father, and the aunt who had testified they were not familiar with that remote family history. But certainly, as to everything that had a direct impact on Mr. Whittle, it was thoroughly explored. But in trying to address what other evidence was presented in post-conviction that had not come out. But again, in terms of you look at the actual statutory mitigating factors, you are supposed to look at the mitigation which was presented before the jury, and you add in the post-conviction mitigation, and you see what the change is. And if you go through, and I was going to try to go through them today, but I'm afraid I don't have time, there really is no real difference. They haven't identified, certainly, any new mitigating factor. There was a great deal of weight given
deep in your
to
rebuttal time.
the statutory and non-statutory mitigation. So with that, I will take a break and be back, I guess.
Thank you, Your Honor. Mara Louise Parmer, and along with my co-counsel Maria De Liberato, on behalf of the appellee, cross-appellant, Mr. Whittle. I would like to first address the appellee's claim of ineffective assistance of counsel in the penalty phase, and then later on address the cross-appeal issues regarding...
Well, I'd really spend time focusing on not sufficiency, but on prejudice. And what the last thing that was said was that it was really just everything that you're saying should have come out actually came out. And you've got to, in maybe order of significance, We have a 89-page order, and we've got 9 days of evidentiary hearing. Qualitatively, what was missed that should undermine our confidence in the outcome of this penalty phase?
Well, first off, I think there was an overwhelming amount of mitigation presented in post-conviction.
Well, we understand that. Again, in other words, you did a good job of putting on 27 witnesses, but we have to understand qualitatively what was done at the trial and why we should not have confidence in the jury's recommendation of death based on what was presented. That's how I see our job here.
Yes, and I understand. What I wanted to say was that what I've done is, in anticipation of this question, is broken it down. There were essentially 5 areas of mitigation that were presented in post-conviction that were either not addressed at trial or only marginally addressed. And the question, the United States Supreme Court has made it very clear in Sears v. Upton that they have never denied a prejudice case simply because there was mitigation presented. So the question for this court isn't whether or not there was mitigation presented at trial, but whether counsel was deficient, which the post-conviction court found, and whether the additional evidence undermines confidence in the outcome. First area that I want to talk about is the expert testimony of Dr. D. The state of Florida told this court just now that Dr. D was very familiar with alcohol, the history of alcoholism. There is no testimony from Dr. D at either trial about the effects of alcohol and how that would have affected Mr. Whittle on the night of the murders, even though their theory was that Mr. Whittle was so intoxicated that he was in a quote-unquote alcohol-induced coma. In post-conviction, Dr. Buffington came in and testified about the effects of alcohol on the brain and how it affects the thoughts and processing, and he also explained the phenomenon of blackout. And he explained how...
Let me add, before you go any further from the alcohol.
Okay.
Wasn't alcohol and drug abuse found as a mitigating circumstance in this case?
Yes, it was given little weight.
Okay, and that was based on what testimony?
Tommy Whittle's testimony.
At the 2004 penalty phase.
Right.
And did Dr. Dees at all, I can understand you're saying that you now have an expert who really talked about the effect of alcoholism, but was that discussed at all? Not the effect, but the amount of alcohol, when alcohol was consumed, those kinds of issues, were those discussed during the 2004 penalty phase?
Well, Mr. Whittle talked about how much...
By Dr. D. She's asked by Dr. D.
Oh, by Dr. D. No, he didn't talk about that. There was no expert testimony that said, we can anticipate if someone has... Dr. Buffington in post-conviction did a range of what Whittle's blood alcohol level would have been and how that affects the brain.
Okay, I understand that you have the effects of the alcohol, but you're saying, let me just finish. Are you saying that Dr. Dees never said anything about alcohol at all?
He was never asked about alcohol.
I just want you to make it clear what you're saying here.
He was never asked about alcohol, and when trial counsel was asked, did you ask Dr. D about alcohol, he said, well, I sure hope I did. I can't think of a reason not to, but he didn't.
Didn't they find in both cases that as non-statute mitigation there was alcohol and drug abuse?
Yes, they did.
In 98 and 2004?
Based on that was their theory of defense, but if you don't put that theory of a defense, if you don't explain to a reasonable juror what that means, if you don't explain to a reasonable juror why the Eighth Amendment tells us that we should care about that, most jurors don't have the sophistication and knowledge to understand why that's important. And even the sentencing judge only gave that mitigating factor, I believe, little weight. I don't know, I don't want to misspeak, but I'm pretty sure it was given little weight. Nothing was given any more than moderate weight. Most of the mitigators were given little weight. And this was their whole theory of their case. Now, the other...
Let me, if I can
Sure.
ask you about your characterization of, I believe it was Dr. Buffington's testimony, post-conviction expert testimony concerning alcohol. Dr. Buffington?
Correct, yes, that was the
Now,
expert.
you said, you mentioned that he referred to a blackout being the consequence of the abuse of alcohol, and those could lead to that. How can that be, how can the theory of a blackout here be reconciled with the confession that the defendant in this case gave?
That's an excellent question, and that's exactly
That's why I ask it.
That's exactly why Dr. Buffington addressed that and explained that, because most people, if you haven't experienced an alcoholic blackout yourself, would not be familiar with what that experience is like. In a blackout, you can have either a complete blackout or you can have a partial blackout, where you're walking and talking, and you may have snippets of memory, kind of like clips from a movie that are somewhat disjointed. If you listen to Tom Whittle's confession, which is in tape and is part of the record, you can tell that he had a disjointed memory of what had happened. He was a very candid...
Excuse me. I listened to the tape. He did not have a disjointed, and he was specific about the woman walking into the knife. He holding the knife to his head, and she turned her neck. And, you know, he talked in detail about what happened and how it happened, and never once did he black out. The only time he was halting is when his story didn't make sense, and he tried to convey, he figured, well, that kind of thing.
Well,
that was only blackout.
But he's not under the effects of alcohol when he gives his confession. It's a day or two later, and he's interrogated for hours and hours and hours before that tape. They've already filled in, the police have already filled in the pieces. He has random memories. He has some memories of the facts of the crime. But he says at the end, I don't understand why this happened, and I don't really, it's not really clear to me. But by the time he's put on that tape, they've given him information and helped him put it all together. But that testimony is consistent with the effects of an alcoholic blackout and a very high blood alcohol level.
He had 3 bags of things that he cleaned up from the trailer, the murder scene.
And bizarrely...
And he was doing this while he was blacked out.
Yes, and that's
Okay.
that's why it's so important, because if you've never experienced a blackout yourself, or if you're not someone who studies the effects of alcohol on the brain, that's not put in context, and it goes to his credibility. In fact, that was what the state of Florida argued on direct appeal is, I'm sorry, I'm getting disjointed, but that testimony was very important because we have to presume a reasonable juror. The Strickland standard says we presume a reasonable juror, and a reasonable juror is going to follow the law, and a reasonable juror is going to listen to what an expert has to say. Dr. Buffington was completely unrebutted. The state of Florida hasn't presented or given this court or the post-conviction court anything to suggest that what Dr. Buffington said wasn't true and scientifically accurate. They had that opportunity, but they didn't do it. So there's nothing in this record to say that this wasn't the case. Now, unless there are other questions on that, I'd like to move on because there's so many areas of compelling mitigation, I don't want to miss all of them. Now, additionally, Dr. D did talk about the fact that there was neglect and abuse, but he didn't put it in context. And he didn't explain why a reasonable juror should care. And if you don't put that kind of testimony in context, you may find yourself with a juror who's uninformed about the Eighth Amendment as it applies to capital sentencing and just say, he was an abused child, why do we care? That's just an excuse. There are plenty of abused kids out there who don't kill anybody, so why do we care? And in fact, that's what the prosecutor argued at trial. Now, of course, for those of us who are familiar with the Eighth Amendment, we know that that is something that we are supposed to care about. But Dr. Cunningham was able to explain that not only was there significant abuse, but the neglect started from an early age. If you look at the trial testimony, it's really not clear where Tommy Whittle even lived. He doesn't have a very clear memory. He was a young child. Where did he go? All of these things. You can't even tell what age they were when they were sent to the children's home. And you get this false impression that they were being taken care of by their grandmother, Ella, who turns out really to be the great-grandmother because the real grandmother is, abandoned Tommy's father. Dr. Cunningham explained that when you are an infant, the most important years of your life are really from age birth to 3. And if you don't have a continuing relationship with someone who cares for you, a lot of children will develop what is called primary attachment disorder. And it's an inability to connect with other people, and it creates lifelong problems. And in fact, primary attachment disorder, through Department of Justice studies, has been shown to have a significant nexus for the risk of criminal violence. And so we know now from post-conviction that from the time he was born, his mother was shipping him off, his father was shipping him off to a girlfriend, the mother was writing letters to the aunt saying, which one of my kids do you want to take? I've got Tommy, I've got Bobby, which one do you want to take? And we know that that continued throughout Mr. Whittle's life. That's a toxin for emotional and psychological development, and that was never explained to the jury. They never heard why we should even care about that. And so we also know that the trial judge actually gave lesser weight to the abuse because the trial judge was under the mistaken impression that Tommy's life got a little bit better as he got older and got away from his father. But in fact, we now know that at age 15, Tommy went to live with his father, and that his father stole his girlfriend and ended up marrying his girlfriend after he had impregnated her. And so we know that that was never presented. Now, I'm not even getting really to Albert yet, but now I want to go to the next area. The third area is about the CODA testimony. There was testimony about being a CODA and what that might mean, but it was done in a disjointed way. I think it's really important to keep in mind that the testimony that was given from Tony Maloney, that was credited by the post-conviction judge, who saw all of these people, who got to watch and listen to the deaf witnesses as they testify, some of whom make guttural noises when they testify. He got to see all of that, and he credited Tony Maloney's testimony that Dr. D did not know that both parents were deaf, and that Dr. D and Tony Maloney realized this was a very significant piece of mitigation, and that Dr. D felt that they needed an expert on CODA. And that Tony Maloney said, we tried to find an expert, but because she had been retained 3 days after jury selection started, there wasn't time to find an expert.
But counsel says that that Dr. D re-examined the defendant between 1998 and 2004. So if we were to go and take Dr. D's testimony in 1998 and then 2004, were there significant differences in his testimony?
I don't think so, no.
We'd have to look at that. But
you would have to look, but I don't think there's anything significant. We know that Dr. D looked at the book Mother, Father, Deaf, which is an anthropological study, and he talked about that, I believe, at both trials. But
that was just given to him by
Tony Maloney
in the first trial, so he didn't do any further research that we know of.
No, and there's no indication from his testimony that he did any further research.
But what's the impact? It's certainly there's a syndrome, and there was a lot of testimony about it. But as far as mitigation, does it go to statutory mitigation? And if so, how, or non-statutory? In other words, it's a phenomenon that's maybe important, but what would the jury take from this that they didn't understand?
Well, I think it's important both. I think it could go to the emotional distress mitigator, and it also goes to non-statutory mitigation. And
did any of your experts, related to any aspect of the crime?
I don't know that it was specifically... It was related to the crime, yes, in a couple of ways. First, one of the things that's interesting about being a CODA, and there's so much I really do want to talk about that, is that deaf people frequently go into each other's homes without knocking because they can't hear. And so if you're living in the deaf culture, deaf people tend to live together in groups, in communities where there is a deaf school, where because the deaf school
So
usually.
did someone explain it, that that's why he went into the trailer?
There was testimony from Dr. Marcus that deaf people routinely go into homes without knocking, and the testimony from Tommy Whittle was that from the beginning was that he walked into the house to see what time it was, which sounds like a really, you don't walk into people's houses and see what time it was. But if you take it in the context of, as Dr. Marcus explained, you had to look at Tommy both as a hearing person and also as a hearing person, as a deaf person in a hearing person's body.
You're in your rebuttal. You had
Okay.
two more areas that you said were not developed. Just if you could at least
Well,
say that.
I
and
think
then-
probably most significantly is this false picture of Albert. In the Attorney General's brief, it's mentioned that there was testimony about that Albert brought helped smuggle people into the United States. That particular part of the record is about a two-sentence statement where he says, yeah, there was this confusion and there were people in and out of our house, and somebody said my dad was bringing people in. The context of that wasn't really put out, was not explained, because what Albert was doing was smuggling deaf people, Mexican deaf people, into the country, one of whom was the person who raped Tommy's brother and Tommy's sister, and possibly even Tommy. And not only that, these people were then being essentially sold into slavery. They were being held against their will and being forced to peddle these deaf cards. And there was a major federal indictment in both North Carolina, where Albert was involved, although he was never officially linked to that indictment, and New York. It was a huge scandal. And so that
When
gives
did that
you...
occur?
That occurred, he was doing that when Bobby and Tommy and Scott were children.
And when did all of this you said there was an indictment?
I believe the indictment came out in the 1990s, but it was certainly available by 2004, if that's what the court's getting to, yes.
And that would have demonstrated what?
Well, because number one, nobody really knew that Albert was a human trafficker. And I think the fact that your father is a human trafficker who carries a gun under the seat of his car and is a drug dealer and there were two witnesses, Bobby and another man, Jesse Church, a deaf man from North Carolina, who came in and testified that he was afraid to testify because he was literally afraid that Albert Whittle would kill him.
Well, the point is they put on Albert not knowing and gave a picture like he's a great father, not knowing this other information.
Because they didn't investigate it. They never went to the deaf community, and that information was there. Those people were available.
Before you run out of time, I want you to clarify for me, you had 4 mental health or experts testify, maybe not mental health, but 4 experts that testified in this case?
3, I think. Dr. Cunningham, Dr. Buffington, and Dr. Marcus.
Okay. And tell me how did any of these experts interview the defendant, or did they talk to him?
They all
They
did.
all talked to the defendant.
They all talked to him. Yes.
Okay. All right.
So the one other, the deaf community and the multi-generational information was really important in this case. I mean, some people might mock it and say, oh, who cares? But when you read the record and you read the testimony, it's particularly important in light of the fact that Mr. Whittle was a CODA, because you have to look at the parents, and then you also look at the grandparents, and you've got these layers. What happens is that deaf people generally have hearing parents, and they generally produce hearing children.
Weren't most of these experts CODAs also?
No, we only had one CODA expert, and we had a woman who was a CODA herself who knew
Counselor, right.
who knew the mother and had actually helped the mother. And we also found out the mother was mentally retarded. That hadn't been presented.
But now the essential element here is, CODA is important, but the social, economic, and dysfunctional background was the most important part of this whole discussion, was it not? Because CODA people aren't just automatically criminals, are they?
No.
Okay.
And yet that's exactly right. And that's exactly a good point, because it wasn't just that the parents were deaf. It was who were these deaf people within the community. And that was never explained at trial. And now we know that they were peddlers. And now we know what peddling means. Peddling is deaf people preying on other deaf people and using them to make money and peddle these deaf cards. And it's shameful in the deaf community. We also know that the mother was rejected in the deaf community. We presented, all of this in keeping with the ABA guidelines that are cited in my brief. We presented and explained, who are deaf people. And I, personally, I never really knew anybody who was deaf until we did this case. And it's a whole social and cultural community that was never fully explained at trial and was really important in understanding Tommy and in understanding how Tommy talks and how he speaks. I see that I'm, I think, totally out of time at this point, so unless there are further questions, I will.
Thank you. Rebuttal?
Thank you, Your Honor. First, on the alcohol. The trial court did weigh the finding, both the statutory mitigator of substantial impairment, which she based primarily on the alcohol consumption. She says at one point she's giving it moderate weight, and then she says, she recounts some of the facts, and she says because he was still able to engage in goal-directed behavior, and the example she gives is he was able to realize that the woman that he was trying to kill wasn't dying, and he leaves her in the bedroom, goes into the bathroom, gets the toilet tank lid off the toilet, goes back in and strikes her in the head with that so hard that it breaks into chunks. And she uses that as the example. She says he clearly wasn't so substantially impaired that he wasn't thinking and he couldn't do these things, so I'm only going to give that little weight. Now that's important because when Dr. Buffington comes in, he acknowledges, yes, even if you have, there are different kinds of blackouts, and in one blackout, a partial blackout, you are still going to have those thought processes. You're going to be enough with it.
The problem I have here, and I know you don't concede deficiency, but let's assume deficiency. We go in a case from a 12-0 and a 9-3 to a life recommendation and 7-5, one juror, and yet you had a lawyer who really gave this case a lick and a promise, and a trial judge who listened to 9 days, and although he doesn't say it, clearly thinks that this defendant didn't get a fair shake at sentencing. And when we look at all these cases that are in death row and we say one vote would have put this defendant for life in prison, and all that we do to defer to the trial court, what is your best argument for why this shouldn't go back as the trial court ordered for a new penalty phase?
Because again, it's the same picture, and if you look at what this court says you look at to assess prejudice, you look at the statutory and the non-statutory mitigating factors that were weighed and everything that went into considering them.
So you don't look at whether, because we don't know what the jury weighed. How do we know that
well, we know the evidence that they had, and when you talk about the trial judge making this determination, something you must keep in mind is that Judge Hunter, who rendered the post-conviction order, was not the resentencing judge.
I appreciate, but we have 12 jurors that said no death for...
and I think this court has said several times, when you have a 7-5 recommendation, that's a pretty good sign that your defense attorney is doing a pretty good job. And when you have these horrible double murders, these brutal murders that come in Polk County, and you have this case, and you end up with these kind of recommendations in 2004, I think you have done a fabulous job as a defense attorney.
Do you agree with the representation of counsel with regard to the deaf culture evidence that came in and the trafficking and all of that? Do you agree that came in only in post-conviction and was not touched upon?
No, there was some evidence from Bobby, some testimony from Bobby at the resentencing about the people coming in through the house. And another point I want to make, Dr. Marcus.
Was it? Again.
I'm sorry.
I've never known you to not be straight up with the court, so I'm asking, did they talk about the trafficking, the human trafficking, and making these people use the cards?
I do not recall the extent they talked about the peddling. I know that Bobby talked about that they were coming in, and my impression, and Your Honor, I certainly don't want to mislead the court, was that Bobby did talk about how these people were always coming in, and the impression I had is she's talking about them being illegal immigrants, but maybe I don't know that term is given to them. Certainly this indictment, whatever came out in the 90s, that was not discussed. But the fact that there were many, many strange men in and out of her home and that she was raped by them, that all came out. That came out in 1998 and in 2004. So the whole, and the idea, there's no objective reading of this record from resentencing that would leave you the impression that this father was a good father. That is just not you do not get that impression. Yes, he testified. He said some strange things when he testified, and he did say, there were times I took my son fishing and we did father-son things, but certainly Dr. D comes in. Dr. D said this father wasn't even around most of the time,
Well, doesn't that
and when he
sort of
was a
show
horrible father.
we're going to just throw on who we used last time? I mean, if there wasn't any purpose for his testimony, why was he put on?
Well, I think he had some very good testimony, and I think it helps give the jury a flavor of the home environment, and he certainly talked a lot about the mother. Dr. Marcus and Dr. D both made the point that it really wasn't the coda, it was, as Justice Perry said, the socioeconomic factors and the horrendous abandonment. They both said that was a bigger factor than the coda. Even Dr. Marcus, who would not have been available as a witness in 2000.
Those go hand in hand.
Yes, they do, and
They go
they
hand
were
in
both
hand.
discussed in 2004.
Folks living in deaf cultures, they do go to areas,
Absolutely.
and they do center in those
And-
areas, and they do suffer socioeconomic issues.
And the
So-
jury did hear all that in 2004. So all of that was available. And I do want to just point out a record site because Dr. D did talk about his alcohol consumption, that it would have been more than the 7 or 8 in the statement he gave to the police. That's in Resentencing, Volume 16. I have 2450 is the page site. So around there he is talking about, and there were other witnesses at the penalty phase at the resentencing besides Mr. Whittle who talked about his drinking that night as well. So that was a major theme. And I think if this court goes back and reads Mr. Cologne's closing argument to the jury, I think you will see how all these themes were weaved in very eloquently. And he tied it to the facts of the crime about this whose repressed feelings against his mother coming out with this female victim. So he also ties the background into the facts of the crime in this case, and it was very compelling mitigation. So I would ask this court, based on that, to reverse the order granting post-conviction relief below. Thank you, Your Honor.
Thank you. I'll give you 2 extra minutes for your rebuttal and your cross appeal if you like.
The other issue going on to the cross appeal then is that the lower court's ruling on the Brady-Giglio violation. And what we know in this particular case is that the snitch, Arthur White, was allowed to testify falsely about the number of prior convictions that he had. We know that trial counsel didn't investigate Arthur White's background, relied simply on what the prosecutor told him was his prior records, and didn't bother to obtain certified copies, so would have been unable under clearly established Florida law to even impeach Arthur White. Arthur White also testified that he didn't have a deal. But what we know about Arthur White is that this is a repeat violent offender. He has only been out of prison for a couple of months at a time since about the age of 17. He was the key witness in talking about the fondling. There was no other reason to put Arthur White on because Tommy Whittle was very candid and admitted to the crime, showed great remorse for the crime. So the only thing that Arthur White had to present was this fondling, which the trial lawyers admitted created the yuck factor. This court, in fact, on direct appeal, the direct appeal attorney suggested that it was an unobjected to comment, therefore it was under fundamental error, and that regardless that it was so egregious to not object to this, that it was ineffective assistance of counsel on the face of the appellate record. Arthur White, we know that the lawyers did not cross-examine him on the wrong number of convictions. Had they done so, they would have been able to bring in all this information. We know that he got sweetheart deals, and we also know that he falsely stated that it was a disadvantage for him to come and testify because he was losing gain time in prison, when in fact his prison records show that he was in so much trouble in prison that he was constantly in solitary confinement, which is also interesting because we know that Tommy Whittle is a model prisoner. And so I believe that, or I suggest to the court that the lower court's ruling on the Brady Giglio violation was an error, and that this court should not only affirm the grant of the penalty phase relief, because there was a complete breakdown of Mr. Whittle, of the adversarial system in this case, and Mr. Whittle's right, Sixth Amendment right to present mitigation. But not only that, but also should reverse the lower court's ruling on the Brady violation. If there's nothing else, I would conclude. Thank you very much.
Thank you for your arguments. The last case for the day is the Florida Bar versus Johnson. Counsel ready to proceed? You may proceed.
Good morning, Patty Savitz, Bar Counsel with the Florida Bar, here for the complainant. In these three consolidated matters, the respondent should be disbarred for his blatant, total disregard for two separate orders issued by this court, as well as his taking money from his trust account. The respondent was the subject of an emergency suspension order issued by this court in April of 2011. Contrary to the conditions of that court order, the respondent continued to practice law on at least three separate occasions. Yes, ma'am.
Let me clarify something here. You just said a few minutes ago, as well as the respondent taking money from his trust account. Was that really the case, or was that proven here that he took money from his trust account, or was this really more that he allowed his employee to have access to this and that she took money from the trust account?
The evidence in the record shows that the respondent took money from the trust account on more than one occasion, took funds from the trust account and used them for his own personal uses. There is also evidence in the record that shows that that employee took money from the operating account, not the trust account. The expert testimony shows that the only individual, the only certified public accountant to complete a compliance audit of this trust account was the bar's chief auditor. The bar's chief auditor prepared an exhibit that was received by the referee, a summary comparison that showed the multiple occasions in which the respondent took money from the trust account for personal uses. In addition, money was taken from the trust account to cover shortages in respondent's operating account. And in fact, respondent admitted in his testimony that on 14 separate occasions, he saw negative daily balances in his bank statement for his trust account. The expert that I referred to testified that in 22 of the 23 months of the audit period at issue here, respondent's trust fund lacked sufficient funds to meet all his clients' liabilities. 22 of the 23 months of that period. So in fact, the evidence does show respondent did take money from the trust account.
Respondent versus the bookkeeper?
Yes, the bookkeeper testified before the referee that she took money using an ATM card from respondent's operating account.
Did the referee find, I thought the referee did not make the finding that the respondent himself took the money to use personally.
The referee made findings that the respondent's trust account did not contain sufficient funds.
I understand, yeah, but we're
Right.
talking again, and I think with these two things that happen after the suspension, that probably bumps this up to something much more significant. But I just want to, and significant no matter what, but most of the trust account cases we have, there is evidence that the respondent has used the money for his own purposes. In this case, as I understand it, no client was ever out any money, and once he realized what had happened, he made it right for the clients. So, but you're saying no, that there's evidence that this respondent was actually taking out money from the trust account for his own or other purposes, and it wasn't just the bookkeeper?
Yes, Your Honor. The record
And the referee found that.
What the referee found that the respondent took money from the trust account at points in time he was not entitled to taking that money. The referee used the term technical misappropriation. That's the referee's term in the report of referee.
And where did the money go?
The money went into the operating account, Your Honor, and from there was used for personal uses by the respondent. The expert testimony, the only expert to complete a compliance audit of this trust account, testified before the referee stating that the money that was taken from the trust account was taken from one client's funds held in trust to pay the respondent at a time when the client was not entitled to that money. So in fact, the referee did find that. It's the bar's position that that is stealing.
And how much was involved on that occasion?
There were multiple instances found by the bar's auditor in situations where the funds were taken in advance of when they were entitled, which means you're taking client A's money to pay yourself. You're taking client A's money when you're not entitled to that money. The auditor also found that money was taken oftentimes on behalf of that same client twice. So the respondent paid himself twice from funds he was not entitled to. The expert testified clearly that in matters of trust accounts, because trust accounts, as we know, are sacrosanct. They're sacrosanct because they're other people's money, and you cannot, for whatever reason, timing or otherwise, take money and use it that you're not entitled to.
This was, what I understand is the money in these trust accounts were actually, because he was helping them consolidate their debts, and the money was there for the purpose of not his fee, but for paying off the debts?
Through the bar's investigation, Your Honor, the bar began, one of the questions you asked
That's
earlier,
what I had the understanding, and maybe again, that was why anything that would go into the operating account would be especially problematic, because that was not where earned fees were deposited. Those trust accounts were for paying off the creditors. Am I incorrect about that?
Not necessarily. What the evidence shows, though, is that when you ask the question about client harm, in fact, there were two initial clients that were harmed. Their settlement checks, their personal injury settlement checks, were returned for insufficient funds. That's the genesis of the case. From that one trust account, Your Honor, the bar discovered multiple other trust accounts dealing with those clients who, as you were saying, tried to get their debt issues and under control.
But that's not the trust account. Those were separate trust accounts, the ones for the debt consolidation clients?
Yes.
Versus the trust account for people who may have had, say, a personal injury case or something?
Well, in fact, Your Honor, all the trust accounts were deemed attorney trust accounts. The fee agreement signed by all these clients specifically said their client money, whether debt settlement cases or personal injury cases, were going to be held in the trust accounts of the Johnson Law Group, the respondent's law group. The respondent had at least 7 separate trust accounts. The bar only received sufficient records for the one trust account, and that's the account that we were able to do the compliance audit on. That's the one where the bar's auditor was specifically able to identify funds taken from trust, moved to operating, and then used by the respondent.
And
Are
this
you
is the
saying that we
count-
don't have a production of 6 trust account records? Is that what you're saying?
That's correct,
And
Your
that
Honor.
still stands as of today?
That still stands as of
And
today.
was there a proper request?
Yes, Your Honor, there
And
were,
what did the trial judge do with regard to that? Just ignore it?
the trial-
Referee, I'm sorry.
The referee, Your Honor, found that the respondent failed to comply with the minimum requirements set by this court and the rules promulgated by this court for the minimum trust account procedures and the minimum trust account records. For the balance of those trust accounts, the bar received minimal records, insufficient records for the bar's auditor to conduct a compliance audit, and that was despite repeated requests. The evidence before this court shows...
Well, I don't understand. How can you have a subpoena to the bank for the 6 other bank accounts and not get the records?
We received the bank statements, Your Honor, absolutely. The bar used the tools that this court has given it by subpoenaing the bank statements. The records that were missing are the records that attorneys are required to create and maintain when they hold other people's monies. The ledger card, the journal, the monthly comparisons, the
So
reconciliation.
you had no lawyer accounting for those 6 separate bank accounts?
Correct. We had bank statements. We had some minimal here or there sporadic comparisons or reconciliations that the bar's auditor looked at, and the bar's auditor's expert testimony to the referee was what had been provided, number one, did not meet the repeated requests of the bar, both by letter and by subpoena, number one, and number two, these records were insufficient for a compliance audit to be done on these remaining accounts. But what we do know is, in fact, from the one trust account in which the bar was able to do a compliance audit based on corrected records from the respondent's accountant that he hired. His accountant did not do a compliance audit, but corrected the records. From those corrected records, the bar's chief auditor was able to determine that, in fact, between anywhere from $5,000 to over $150,000 for a period of 22 months, respondent's trust account did not have sufficient funds to meet those client liabilities.
And what did the referee actually say about that? Because I didn't think the referee had actually made any kind of finding under the rule that talks about commingling. Because commingling is, taking that money and putting it. So what did the referee say about that?
What the referee said, Your Honor, is the respondent was unintentionally neglectful of his trust account. And as we know from this court's prior holding, there is no such standard as unintentional neglect. We have gross neglect, we have neglect, and in fact, the referee's findings in his report of referee clearly establish, along with the evidence that the referee received, that we have gross negligence with these trust accounts.
Did the bar, is a part of the bar's argument, or did you make an issue of a lack of a finding that there was commingling?
What the bar made an issue in its brief, Your Honor, is that the record before this court, the record as summarized in the findings of fact by our referee, clearly establish intent under the standards set by this court for a violation of 4-84C in the Fredericks case, in which this court tells us that intent is established by knowing, deliberate, intentional conduct.
You're getting close to the end of your argument. Could you
Yes, Your
tell
Honor.
us about what happened subsequent to the entry of our order of suspension? What conduct you're alleging was a practice of law after he was suspended?
Subsequent to the entry of this court's emergency suspension order in April of 2011, the respondent, contrary to that order, did numerous things. First of all, he continued to practice law. The referee found in at least 3 personal injury matters. Not only did the respondent settle those matters, he corresponded on law firm letterhead, email letterhead, fax correspondence letterhead. He received the settlement proceeds from the other side, deposited those into a brand new trust account opened after the emergency suspension order, and then dispersed from that trust account, contrary to this court's order that says you shall not make any more disbursements subsequent to an emergency suspension order. In addition to which, the respondent filed an affidavit with the Florida Bar indicating he had notified all his clients of his suspension order, when in fact he neglected to notify 13,000 clients of his law firm until well into August, some 4+ months after the entry of the order. And then our second order that's at issue, in July of 2011, this court entered an order pursuant to Standard 2.8D, appointing a receiver to conduct a forensic audit of all these accounts that we've talked about this morning for the purposes of determining the status of the funds and claims of ownership. Respondent represented to this court that he would retain and pay for the services of that receiver. We are here 22 months from the date of the entry of that order, and the respondent, despite having received nearly $500,000 from the sale of his law practice clients, despite that amount of money from August of 2011 to February of 2012.
You're almost out of time.
Yes, Your Honor. The respondent has taken no steps whatsoever to comply with that second order. I'll reserve the last few minutes. Thank you.
May it please the court. Michael Moore, representing the respondent, Clint Johnson.
How are you going to divide your time with
7.5 minutes.
But are you discussing different issues?
I am not, Judge. You're free to ask me
Well,
any
the
questions.
first issue I just want to understand is, are the clients in this case that had money in the trust accounts, have that money been dispersed to them, or is it still being held up because there's been no receiver?
It has not, Judge. And
It has
that
not
is-
what?
It has not been dispersed, Your Honor, and that
Well,
is...
don't you, I mean, to me, frankly, that makes the second violation, which is that after a stipulation that there would be a receiver so that the clients who were had money owed for their debts could be paid, that we're now talking about 2 years later and that hasn't happened?
Your Honor, I think that assumes that Mr. Johnson had the ability to hire the receiver. He did not.
Don't you think there's something called a motion to ask for some relief that should have been filed?
Judge, Mr. Johnson did, in fact, with prior counsel, file a motion to release the funds to pay the receiver. The bar objected, and the court ultimately denied it.
So at the time he entered the stipulation, he didn't know he didn't have the money to have a receiver?
The bar was very strict in their conditions to have him sign.
What?
They were very strict in their conditions. They were very specific. That notwithstanding that Mr. Johnson would not have the ability to know what the receiver was going to charge him, because his funds were limited at this point. He didn't have the ability to pay. He had no personal or professional income coming in.
Why would you enter into a stipulation saying you're going to do something when you know you don't have the ability to do it?
Your Honor, at the insistence of the bar and in good faith, he entered into it. He did.
Well,
and on advice of counsel.
The bar can't make the lawyer do something that he, if intelligently is decide I can't do this. I mean, the bar is not God. Don't you have a referee or something that intervenes in these things?
Your Honor, I absolutely agree that the bar is not God, but they insisted, at least at that point in time, that he sign it with no other details to be given to him about what the receiver was going to require financially. It was open-ended.
What was the consequence if he had not signed it?
I don't know the answer to that, Judge. I don't.
See, that's the problem is, if you know you can't do something, why would you stipulate that I'm going to do it?
Judge, let me emphasize again, he did it on advice of counsel and to demonstrate his good faith that he was willing to try.
But once he found out what the charge was, Why not go to the referee for relief? The last thing the Bar Council says is that your client got $500,000 from the sale of his law firm. Is that correct?
That is, Judge, but it was months and months after the issue had come up and after stipulation had been signed.
But you're just saying that still the money is still there, the receiver still hasn't been hired.
Judge, let me be as clear as I can with the court. Mr. Johnson absolutely wanted to release the funds as it relates to his fees and that he was owed so that monies could come out of that to pay the receiver. Sufficient funds, more than enough. The bar objected. I don't know why.
Well, because you don't know until you finish an audit on whose money that is.
Your Honor, let me be clear about this.
Isn't that true? I mean,
that is true, Your Honor, but there were two experts, if you will, that represented the bar. Counsel's referenced them, that they came in and conducted a comprehensive audit. In addition to that, my client, Mr. Johnson, hired 3 professionals that were experts, if you will, as it relates to trust accounts. Everyone agreed, and I don't think counsel will dispute that his trust accounts were in order. No question about it. And they knew what monies were available in each account. And again, the monies were sufficient.
What she just went through is a far cry from his trust accounts being in order.
Judge, I will tell you, the good news is that there is a record by the referee that specifically sets out that Mr. Johnson not only had his records reconciled and everyone agreed to it, but that he didn't take a single penny.
What she described was that he was using his trust account as another checking account, essentially, for purposes of funding an operating account whenever a need arose. Do you dispute that?
I do, Judge. I do, and I think the record is clear that he did not.
So those deficiencies she talked about in the trust accounts just don't exist?
No, Judge. The deficiencies existed prior to the issues that arose as it relates to the frozen accounts. Let me be clear. What happened is he had a rogue employee who was stealing from him $50,000. So she was the person, not Mr. Johnson, who was transferring funds from one account to hide from him. She didn't show him the statements from the bank. She hid emails that came from his accountants that said, I've got some concern here. He never saw it. The first time he got wind of a bar action at all was when his assistant, who was stealing from him, showed up at court doing a break in a trial and says, look, I forgot to give these to you. Sorry about that. You got to be at a deposition pretty soon.
But
he had no clue.
But it sounds to me you just admitted that your client had deficiencies in that trust account. Is that correct?
Only because of a outside element, Your Honor. Yes.
Okay.
Yes.
You said that there existed deficiencies prior to the thing about all of the receiver. Your client knew that there were deficiencies, and there were, in fact, deficiencies that were pointed out by the audit and that came before the referee. Is that correct?
That is correct, Judge.
Okay.
The point in time is important, though. There were deficiencies prior to the audit being conducted. And the only 2 issues, never any issues with this account prior, was that there were 2 bounce checks. Why did that happen? Because his assistant, who he put his confidence and faith in, did not deposit the settlement checks before writing a check out of that trust account.
Well, what about the other records that did not exist on the other 6 trust accounts?
Judge, I am not aware that there are records that are not in existence because, as I've stated earlier to the court, 5 different individuals who are so-called experts in accounting-related in the accounting-related industry have agreed that Mr. Johnson's accounts were in good order after they conducted their audit.
And so why
there were no missing documents?
If that's true, why wasn't the documents turned over? The bar says that they got information from the bank on the other trust accounts. They did not get all of those things that an attorney is supposed to keep for a trust account. If they exist, why have they never been given to the bar?
Judge, to my knowledge, that has never been an issue. This is the first time I have heard of it as Mr. Johnson's
So your client
counsel.
was never asked for that information?
Judge, I cannot answer that, but I will tell you this is the first time it's come to my attention.
I thought the judge found that he did not keep proper records. I mean, he said that was technical, but we don't see keeping trust account records for each trust account as being technical. You're saying you just don't know whether that's the case? I mean, the trust account records, or that he did keep proper records?
I apologize. Your Honor, are you asking me whether or not I'm familiar with whether the referee identified specifically that there were records that were missing?
At this point, I feel like we're hearing in 2 different cases. Like you're defending one person and they're prosecuting another, because it's not making any sense
Let's
to me.
move on to your co-counsel.
All
Maybe
right.
we can get some clarity.
All right. Thank you, Your Honor.
I have a question that I'd like to start out asking you, and that is it true that your client opened a trust account while he was a new trust account while he was suspended as a lawyer?
That is correct, Justice Kennedy, and if I just may introduce myself, Tanya Lal Jimenez, on behalf of the respondent.
Well, you need to speak up.
Is that better, Your Honor?
Yes.
Just to clarify, that trust account that was opened was in an abundance of caution. Mr. Johnson opened that separate trust account for any additional monies earned. He put that in a separate trust account. To date, he has not touched one penny from those funds. So that trust account was specifically for fees earned post-suspension.
No checks have ever been written from that account?
No, Your Honor. To my recollection, he opened a specific...
Well, is it or isn't it? I mean, that's really what we're talking about. You get into a court of law, to my recollection, you're a lawyer representing a lawyer. Were any checks issued from that trust account?
If I may go back, Justice Lewis, if we look at the report of the referee, his specific findings were that no monies were taken by Mr. Johnson from his trust funds. I didn't ask that question. Were any checks issued from the trust account, ma'am? One of them, yes, Your Honor, and that was during the wind-down phase of the practice. Mr. Johnson clarified with the referee in the record, that's in the record, about monies earned and to be disposed to medical providers, clients, not to himself.
When the court enters an order, it doesn't mean that lawyers who are under a suspension can just decide which checks they're going to write out of trust accounts. So I appreciate you finally admitting, but I don't appreciate that you said your recollection. I mean, this is something that's very serious. And checks being written out of a trust account after a court has entered a suspension order and then ordered that there be none is a significant matter.
Absolutely, Your Honor, and I'm sorry, I misunderstood what your question was. And if I may go back, when we go back to the proper sanctions...
Well, let me ask you, did he practice law after the suspension order was entered?
He did not, Your Honor.
Were letters signed on letterhead of the firm?
Going back to that letterhead, the referee found that was a technical violation. That's where the language comes up with the technical violation.
Technical violations, that's almost like saying violating a statute of limitations is a technical violation. It's pretty significant in my view.
I understandably so. If I may explain and provide some background into this. Mr. Johnson...
Just on this, the finding of the referee was that for 3 personal injury cases, he continued to represent the clients, rationalized the settlements occurred before the suspension, he was just concluding the settlement, actively negotiated for his clients and dispersed funds. Are you contesting that didn't happen and that wouldn't constitute the practice of law?
I'm sorry, Your Honor, if you may repeat that.
The judge's findings that he continued to represent the clients in the personal injury cases after the suspension, that the judge found occurred, are you saying it didn't occur?
There was no negotiations or representations during that time. It was checks being dispersed from negotiations that occurred during the wind-down phase. And if I may go back and just informing the court, Mr. Johnson takes responsibility. He's not saying that he's not here for gross negligence, not properly supervising this employee, which is how this matter came before the court. It originated from those 2 first checks, which the clients were made whole the very next day. And to be noted, in those over 13,000 debt management, debt settlement clients that Mr. Johnson had, there was not one complaint prior to this time.
Here's what I see.
What did he do with the $500,000 he got for his the sale of his law practice? Because it seems to me that with $500,000, there's no reason in the world the receiver should not have been appointed and paid, and that we could get some resolution on this money that seems to be sitting out there.
If I may provide a little background, Justice Quince, regarding this receivership.
You know what? I just want you to tell me what was done with that money and why none of it was used to get the receiver so we could take care of those 13,000 people.
Those people were taken care of before this court entered their order of the stipulation of the receiver. The receivership, there were issues with the receivership. In good faith, former counsel for Mr. Johnson made negotiations with Ms. Savitz. There's no discussion of what that actual fee was, and there's, in the record, even the referee noted that Mr. Iserman, who was going to be the appointed
So the
referee.
answer to my question is, none of the $500,000 was used to do what had been stipulated to by your client about a receiver. That's the answer to that.
That is correct, Your Honor.
Okay.
But going back, the clients had been transferred prior to the court entering their order. Mr. Johnson did take safeguards during this time prior to the court entering their order about this receivership. He filed a petition with the court. The court did ask, didn't he take measures? There's a referee here. He did. He filed motions with the referee, and factors were taken into consideration for that.
What is the appropriate discipline in this case?
Not disbarment, Your Honor.
Why not?
Because it mounts down to gross negligence. In the past, this court has ruled in matters regarding negligence and gross negligence, this court has imposed sanctions of up to 3 years of suspension.
Don't the two orders after, I mean, you might have an argument that he was on the cusp for just a 3-year suspension, but then the two contempts are, especially the second one on the receiver, I don't see an excuse. It seems like the court's orders were just made a mockery of by this respondent.
And I understand the court's concern, and that's not the case, Your Honor. And I see that my time is getting limited, but going back to our brief, we discussed that in detail about the receivership and the factors that resulted prior to that order even being issued. Safeguards were taken, petitions were filed with various courts in regards to that.
Haven't we in the past, when we have entered an order of suspension and a lawyer continues to practice law, hasn't the sanction been disbarment?
Yes, Your Honor. The referee even noted generally this court will seek disbarment, but then we have to look at the factors underlying the standards and the rules, what they take into consideration. The referee noted that there were significant aggravating and mitigating factors.
There was a reason the referee found there was a reason he practiced law when he was suspended.
Going back to these disbursements that were made and noting that it was a moral dilemma that Mr. Johnson made, and the referee even noted that it was a genuine one. He brought it on his own regards, but Mr. Johnson took the stance of protecting those clients over his own, knowing that it would affect, and that's why we're here today, his ability to practice law. In considering those mitigating factors, the referee noted that there was an absence of a selfish motive, that he was remorseful. He was full and free disclosure with the bar, and he was cooperative. And he took all those factors into consideration and went in inconsistent case law.
My final question is, those personal injury cases that he sacrificed his career for, was any fee paid to him from those cases?
Yes, Your Honor, but it's still held in that separate trust account that I believe Justice Kennedy asked for. Those fees have not been touched to date. Everything's been accounted for in regards to not having any improprieties. And in regards to, I see my time is dwindling down, but just wanted to go back to the sanction and the appropriate sanction here. We're not saying that Mr. Johnson shouldn't be sanctioned at all. We're asking this court to approve the findings of the referee who has been in contact with these proceedings in significant hearings, many days. He wrote a very detailed report. He went into his case law and the rules in making his decision. And in going back to the threefold purposes of discipline that this court has considered in the police case, yes, disbarment is the presumptive sanction, but then we have to go into the mitigating factors. And there's significant evidence that the referee found of reformation and rehabilitation. It was significantly underway even before the bar even got involved.
You are out of time.
Thank you.
I would hope that when you appear before the court again, you will more directly answer its questions.
I apologize, Your Honor. Thank you.
Rebuttal.
In answer to the issues that came up on respondent's portion of the case, in fact, only one of the multiple trust accounts had a compliance audit completed. The remainder of those accounts, as we stand here today, pursuant to the expert testimony received by the referee, there has never been sufficient provision of those records in order to complete that compliance audit.
Can you address the referee, obviously presided over all these cases, said that from the uncontested evidence, he's of the highest moral character. He finds that Johnson is genuinely remorseful, that he attempted to make his client's best interest his pole star for navigating his post-suspension actions. He placed his own self-interest at risk in order to act in a way he generally believed to be in his client's self-interest. So I guess we've got, again, the two different sort of images here. One of a defendant, a respondent who has a rogue bookkeeper, and was sloppy in his own oversight, which would be certainly gross negligence. And then another picture of somebody that was actually taking from his own trust accounts for his own purposes. And I didn't really, are you still contending that the problems with his trust account came because he was taking fees for himself as opposed to rather than money that was there for his clients?
Yes, Your Honor, and I realize my time is short. The two primary issues here is in the first report of referee dealing with the theft case, the referee specifically found we cannot, as members of the bar, have a trust account that's subject to such a Ponzi scheme, money in, money out, money that's not mine, robbing my client so I can pay myself. And that's specifically found by the referee. The referee found that those monies were taken from the trust account. The rogue employee admitted taking money from the operating account. And in the second matter, we do have what you read, Justice Pariente, about he tried to help his clients. But what we do have, in fact, is a record, the respondent's own admissions, that between August 1 of 2011, 2 weeks after this court entered the order of a receiver, through December 28th of 2012, respondent admitted receiving $486,000 for the sale of his law practice into his own personal account and depleting every penny of that money, depleted every penny of that money for his own personal obligations, not his obligations to this court pursuant to that order.
You are out of time. If you could sum up.
In summary, Your Honor, the egregious pattern of conduct by the respondent, which started with the theft from the trust account, but culminated with violations of two separate orders issued by the Supreme Court of Florida, clearly established that the respondent should be disbarred. This is not a member who is subject to rehabilitation. Thank you.
Thank you for your arguments. Court is adjourned.
All rise.